Lots of good mornings on the chat. Let us know who's there. Where are you joining us from?
There's a question as to whether the recording will be available on YouTube. Perhaps we need to reply to that.
We can certainly put it on the Facebook, the YouTube account of Fit Europe, yes.
Okay, we've got 150 people online now. Shall we get started? And you've shared the live stream, John.
Yes, it's gone live.
Okay, all right. So good morning, everyone. John already introduced himself, one of the leaders of this session, Fit Europe. This is, of course, for those of you who've just joined us, the Translating Europe workshop towards Common European GDPR guidelines for the translating and interpreting professions. So with Fit Europe and partners across Europe, experts in GDPR and the language services industry. If you want to tweet about the event, we've got two hashtags, Translating Europe and TEWGDPR, which is our event hashtag. And this is also being live streamed on Fit Europe's Facebook page. And as John already mentioned, it will be recorded as well. So if you've signed up, you may also be watching this later on as a recording. Most of today's sessions will be in a webinar format. So attendees are muted and your microphones are off. And the people who you see on the screen now are our project team, our experts, and our hosts. We will finish the formal parts of the program at 3 p.m. CET, so all times are CET. And we will then finish this webinar and move over to Zoom meeting for our last session of the day, which is the breakout rooms between 3 and 4 p.m. So we'll give you a link to the breakout rooms at the end of the day, and that is open discussion for you to come and join us and talk about your concerns, experiences, ask questions from the experts and so on. But otherwise, during the day, we are in this webinar. We've got a few breaks during the day, leave the webinar running and come back to it at the allotted time. So you can see today's schedule there in front of you on the screen. There is somebody looking at the chat and Q&A pane, so use the chat if you've got any questions. At the end of each session, we should have a little bit of time for your questions. We've got one larger panel discussion, and that will end with a quarter of an hour for Q&A. So we'll take your questions on various topics discussed at the panel session then. So without further ado, I think we're going to welcome Krzysztof Nalepa from the European Commission, who's been instrumental in enabling this Translating Europe GDPR workshop. Over to you, Krzysztof.
Thank you very much. Thank you very much, Raisa, and good morning, everybody. We are having this meeting in very worrying times. When we were setting the date for this conference, we had no idea that it will take place after the world as we know it would change completely. As all of you, I have thousands of thoughts about what's going on, but one of these thoughts is that we should continue our normal business and pursue our plans as much as we can. That's why I'm I'm really, really happy to be able to open this conference on behalf of myself and Directorate General for Translation of the European Commission, or strictly saying the Warsaw Field Office of DGT. Well, I'm opening this conference on behalf of the European Commission, so it might suggest, and you may have the impression that I am the main guy behind this project, which actually is not true. We are certainly proud to contribute to this great initiative, but most of the credit should go to others in this case. And let me mention Fit Europe, Freeling Foundation, EU Association of Translation Companies, Polish Society of Sworn and Specialized Translation, TEPIS, University of Dublin, Ireland, University of Lublin, Poland, Irish Translators and Interpreters Association, Translation Industry Employers Association, Polish Association of Translation Companies, Polot. There are quite a few partners who have contributed to this project, partners and individuals, and a special mention must be made of one person who's not with us, as John said at the beginning, Stephanie Bogertz, who approached me about this project a few years ago in the pre-pandemic days, which seems like ages ago now. And she has pushed it through ever since. When the project was finally approved, Stephanie has worked as the main, or one of the main coordinators of this workshop. So I think this conference and the whole project is kind of a child of hers, and it is very sad that she can't be present when this child is like being born. But she's absent for a reason, as John mentioned. Stephanie lives in Lublin region, which, as you may know, is close to the Polish-Ukrainian border, and she's doing a tremendous work in supporting a huge inflow of Ukrainian refugees, which is taking place now. She's helping also with translation and interpretation, because believe me, translators and interpreters are doing tremendous work these days, and they are in great demand, which I think is another example and evidence of how important this profession is. The essence of translation and interpretation is to connect people, and in days like these, this connection between people is simply crucial. So great thanks to Stephanie, and also, if you're listening now, Stephanie has asked us to transfer this message to you. Any kind of support, help is very much needed at the border. Okay, back to the conference. As I said, European Commission is not the main actor in this particular project, simply because GDPR, surprisingly or not, is not a big issue for DGT translators. We have our internal rules and we follow them, but they are, I could say, pretty basic. Nothing compared to the complexity and the multi-level variety of GDPR application that is relevant for translators and interpreters outside DGT in the translation and interpretation market. This is a huge issue for translators, because translators are very much exposed to data handling, and they play various roles in this data processing mechanism. And the interpretation of GDPR varies across Europe. There are many disparities, there are many uncertainties and even concerns regarding the application of GDPR. And that is why I think this project is so crucial. And that is why the European Commission has decided to support it financially and to include it into the Translating Europe workshop project, just because it is the ambition of the European Commission to promote translation, to contribute to the development of translation, and to consolidate the various actors of the translation stage. And that's really what this project is about. So once again, let me say that I'm very proud that we are part of this initiative. I'm very proud that Warsaw Field Office is representing the European Commission here. This project is very complex and long. The conference we are holding now is just a stage of it. It's towards the end of the project, but it's not even final. It has been preceded by a number of surveys and working meetings, and it is going to be followed by the development of guidelines to be used by translators and interpreters across Europe. So this project is first of all is going to be very useful. I think that's what makes it very special and kind of exceptional to the practical part of it. Having said that, and without taking more of your time, thank you very much for viewing. We are very happy that the interest is so huge. I wish you a nice conference, a good day, constructive and inspiring discussion. Thank you very much again, and over to you, Raisa.
Well, over to me, actually.
Over to you, John, excuse me.
Thank you very much for all your kind words and also all your practical support in the last period with this project. And now it is my great honor and pleasure to present Mr. Wojciech Wiorowski, who is the European Data Protection Supervisor. The European Data Protection Supervisor and its office is an independent data protection authority within the EU. It ensures that European Union institutions respect the right to privacy when processing data and also when developing policies. And this European Union body has been particularly active in recent years in issuing a whole series of reports and policy papers about various aspects of privacy, data protection, and so on and so forth. And we are very pleased to have today here the European Data Protection Supervisor, who will make a sort of short keynote speech for our event. Mr. Wiorowski has a degree in law and also a PhD in law. He worked in academia and then in the public administration in Poland for quite some time. Since 2010, he served as the Inspector General for the Protection of Personal Data in Poland. And then in 2014, he was appointed as the Assistant European Data Protection Supervisor. And in 2019, he was promoted to the position of European Data Protection Supervisor. So we are very honored and pleased to have him here today with us. And over to you, please, Mr. Wiorowski.
Thank you very much. I hope that you will be able to hear me well and even probably see me, which was not easy at the beginning because I had some problems with the camera. Now it seems to work. Well, I have to say that this is me who is honored because that's the possibility from the typical European official to say good words about the work that you do every day and the work that is often treated as something obvious, normal, but actually being a Polish native, I speak English only as the working language, and my knowledge of Spanish and Russian is just touristic, and I can really confirm that nothing is possible without the huge work of the translators and the interpreters. In the European Union, which is the organization which is proud of being at the same time the united Europe, on the other hand, the Europe of different cultures, the Europe of different languages, the Europe of different histories, and Europe that is enriching each other. So let me once again say that I'm really amazed by what I see in the EU institutions as far as the translating and interpreting skills are concerned. Being a lawyer and being a lawyer working in the IT field, I can also imagine how difficult is to go from sector to sector and to understand actually who is the one who listens, who is the one who will read the documents, and which language, not only which language as such, but also which dialect, which slang, professional slang and professional dialect has to be used. Well, translation and interpretation was always in the loop of the data protection authorities, but I have to say that for a long time we were somehow neglecting the special situation that the translators and the interpreters have as the controllers and the processors. And that's true that everything which I will say today will be a little bit simplified. So I will not take into consideration the differences that may exist between the ways that you do your profession, starting from the individual translator and finishing with the interpreters working in the EU institutions. Moreover, to start that, actually, I should say a few words about this strange structure that we have as far as the interpretation of the General Data Protection Regulation is concerned. I will try to share my screen to help myself with the presentation. I hope it will work properly. Okay.
Let me just stop my share first and see if we can give you rights to do that. Hold on. Just one moment.
It may slightly help to understand this quite complicated system, but if it's not possible, then I will stay with the...
Okay, you should be able to do that now.
Okay, I will try. Yeah, now it seems to work. Okay, I hope now it will be a little bit easier. So I will go from the position of the normal person into the more do we have okay, now it works. To the work of a little bit more focused person on what's going on in this digital world that we have at the moment. So the European Data Protection Supervisor, as was said so far, is the institution which is supervising the European Union bodies, institutions and agencies. So I'm not the super data protection supervisor for the whole Europe, but the role of the EDPS is not only the supervision of the institutions, it's also to take part in the legislative process as the main advisor of the both commission that is drafting the legal acts, and then the Parliament and the Council at the time the legal acts are prepared. Moreover, the third part of our activity is to provide the Secretariat for the European Data Protection Board. And here is the first thing that we have to somehow understand on the roles in interpretation of the GDPR. The guidelines on controllers and processors that were commented by the translators and interpreters community were prepared by the European Data Protection Board as the general guidelines for all the people who are dealing with the European issues and all the people who are working on the European market on how to understand these two main notions that appear in the GDPR. And EDPS was at the same time the member of the European Data Protection Board, because we are, as well as 27 national data protection commissioners plus 3 ones from the European Economic Area countries. We are the members of this body, but at the same time, being the one who is taking it then back to the legislative process in the European Union, my role was to be the kind of representative of this community of the regulators who are accused and often absolutely justifiably accused of having different interpretation in different places in Europe. But I have to say at the same time that the comments that were sent to the EDPB, to the European Data Protection Board, by the translators and the interpreters were among 250 documents that were sent by different sectors to comment these guidelines. Most of these comments that were received asked, is there a possibility to have the special guidelines for this sector, or for this kind of people who may have additional problems with the GDPR? And that's a little bit of a surprise somehow for the data protection authorities, but I think also for the legislators, because during the whole process of preparation of the GDPR, there was one great message sent to the legislators: do not overregulate. Do not prepare the solutions for everything which is granulated, because you don't know the market. You don't know what is the business model of the companies, and you don't know the specific situations that some professions are in, or some kind of institutions may be in. So prepare the principles, and we know how to observe them. And that was actually the main idea of the GDPR, to prepare the accountability, to create the accountability principle, which is consisting of meeting these principles that are in the Article 5 of the GDPR. So all the main principles of the data protection in Europe. So when the GDPR went into force, we started to hear the requests: where are the templates? Where are the checklists? Where are the guidelines? And while the guidelines were expected, and that's good that they were expected, the checklist and the templates will not exist. They simply will not be provided by any central body. But there is a tool which I guess is actually much closer to the expectations of many of the sectors, including your profession. And I'm very happy that this workshop starts today, because it seems to be the road to achieve this model, the model of kind of code of conduct that can code the good practices that which done together with the data protection authorities may serve as a kind of guidelines to the society, but the guidelines which is not given from the center of the huge knowledge and wisdom about the data protection issues, because we are not the one. Of course, we are the ones who are responsible for dealing with it. But to be frank, we are not able to imagine all the problems that may exist on the ground. And the job of being the commissioner for data protection, which I already do for 12 years on different levels, is a permanent education on how the people are operating, what are the problems that they meet during this operation. So both the European Data Protection Board which will be preparing such solutions for the generally for the GDPR, and the EDPS as the European Data Protection Supervisor, working with the EU institutions, bodies, and agencies. We are playing the roles of the auditor and enforcer, of course, and also consultant and educator. But what is probably the most important here, we are playing also the role of the negotiator between the expectations of different sectors and the expectations of so-called data subjects, people whose data is processed, and those who are processing this data, and those who are controlling the resources. First of all, we have to remember that we are not protecting the data. We are protecting the human being. And the data is just the external way of describe the person, describe the person's needs, describe the person's features. But actually, the person over this data is as important as the whole system may be, because the system is created in order to serve the human dignity. I know it sounds pathetic, but actually it's very practical when you start to think that the data that you have in your files and that you decide to use for the different purposes they were collected for, because you need it for the educational purposes for yourself, your company, your entity, or use it for the training purposes, and you're keeping the data in, you are not keeping the data there, you are keeping the people there. So bearing in mind all that, we are trying to make this role of the negotiator in this field. So let me just, at the beginning of this discussion, say about several topics that were pointed to us by the translators and interpreters, and which I'm, as the supervisor of the EU institutions, I'm ready to discuss with the representatives of the translating community in the EU institutions, and which EDPB, European Data Protection Board, will be definitely happy to get the concrete proposal of the code of conduct or code of good practice to get in. I'm not going to go deep in it. I will just number some of the topics. Well, definitely the most important topic is it possible that the translator and the interpreter will become the controller? And the general answer is yes, it is possible, especially in the situation where the data which was collected for translating or for interpreting is now repurposed. And the new purpose for that is, for example, the future training of the interpreters or translators, or the preparation of the professional activity of the company or the entity, or any other way which is not following the initial purpose that was at the moment when the data was collected. If so, if it is possible, does it mean that the controller has all the duties that are laid down on controller? For example, information duty towards all the people that whose data is processed. That's the topic that definitely has to be discussed. And can interpreting be defined as adaptation or alteration, dissemination, making available of the personal data as it is in the Article 4 of the GDPR, or it should be always treated as repurposing and using it for the different purpose. Code of the good conduct and the good practice can be used for the EU translation services, but definitely it can be used for the whole community. And here is the role for the organizations like your one. I'm happy that so many organizations were somehow involved in the preparation of this workshop. I hope that you will be able to start the activity, which as far as I know has not been started yet on the all European level, and you will be able to help the whole society or the whole community of the translators and interpreters in following the solutions from the last reform of the data protection law. I decided to take part in this workshop myself today in order to show how important the subject is among all these points that we do for the hundreds of sectors inside the DPS and inside the DPB. Why so? Because you are 3 steps ahead of the other sectors. You already started the discussion, you already know what are the basic problems, and you already have the ideas how to solve them. And these are not the ideas that you are talking about in the radio or in the in Twitter, but you are talking about it at the meetings of the people who have something to say about the future of this profession. Thank you very much. I hope I didn't bore you to death with this initial statements.
Many thanks, Mr. Wiewiorowski. It's so fascinating. So often we just see the authorities as a mass, the national data protection authorities, the European Data Protection Board, the European Data Protection Supervisor. We see them as a mass where actually we need to look beyond and understand how the different authorities work together and work together with the sectors. So we absolutely look forward to continuing on this journey, and thank you so much for your support. We've made notes of code of good practice. I think that is also the direction that this project needs to move into. We've identified, and today we're identifying many of the issues, the challenges, the grey areas. Then we move on to the next stage of trying to find the solutions for the whole of the sector. So many thanks for joining us today, and we look forward to sharing our report with you in due course.
Yeah, and from my part, I would also like to thank you for your fascinating insights and also for your support in coming along today and for taking the time to properly consider all our points of view that we set out in the consultation process. Because as Raisa said, we often have the impression, that you're quite far removed, and it's very heartening to us to see that you actually, as organizations, did take the deep consideration what we said and looked at what were these important issues. These are important topics for translators and interpreters, and it is important that we do produce guidelines, code of practice, whatever you call it, so that everyone can be more compliant with GDPR. So a massive thank you from all the organizers of this event and of this entire project.
Thank you very much. I'm staying with you as the participant.
Okay, thank you.
Okay, our next topic here, whilst I share my screen again, is John's introduction to our project and to the background of where this all started, entitled, "Are you ready to take the risk?"
Yes, so could you move on to the next slide, please, Raisa? So yes, as Raisa said, this is a general overview so that everyone is on the same page and they know what the project is about and how we got to where we are today. So this all started in 2018 when Stephanie approached me about the idea that we needed to do something, that various organizations around Europe in the translating and interpreting sector needed to come together and to work on guidelines for the GDPR, because there was so much confusion in the social media, because there are lots of groups of translators and interpreters on the social media, on Facebook, on Twitter, and so on and so forth. And there are also the associations, translation and interpreting associations around Europe were also confused about what does this new piece of legislation mean for us as a profession. So one of the first steps that we took was that Fit Europe, with its partners, developed 2 surveys. One was addressed at freelance interpreters and translators, and we had a massive response to that. I think 1,300, 1,400 people. So that gave us a very clear snapshot at the beginning of 2019, what the state of play was, the awareness among translators and interpreters and their understanding of GDPR and their obligations, and whether they were actually doing anything about the requirements in GDPR. And we also conducted a separate survey as well for translation and interpreting associations. So that only gave us, of course, part of the picture of what was going on with GDPR, the freelance interpreter and translator perspective. But Fit Europe is also a partner in something called the European Language Industry Survey, which is conducted every year. It brings together also a very large number of actors in our sector, translation companies, training institutions, so on and so forth. And the European Commission is also heavily involved in that survey. So what we did was we started including questions in the LS survey in the set of questions which relate to translation agencies, translation companies, to get their perspective as well, so that we had a more complete picture of the awareness of GDPR and what was being done. And then once we had that data in place, we started reaching out to other organizations around Europe and trying to put together a project team to push the project forward. Raisa, could you move to the next slide, please? And as the European Data Protection Supervisor pointed out in his very interesting talk, there are quite a lot of different interpretations of GDPR. And this is also one of the key things that started our interest in this, because we were receiving reports of translators having to sign contracts with translation agencies where they were being told that their role was controller, or that they were joint controllers, or that they were processors. So there didn't seem to be any consistent understanding in the sector of what roles needed to be assigned to people. And we immediately recognized that there was a lot of potential for confusion over this issue. And so that's why we put the team together to try and figure out what is the correct interpretation in relation to our specific profession, so that everyone was empowered and that they could know if they were, for example, given a data protection agreement to sign and they were assigned the role of controller when in fact they were a processor, that they could have the document amended. So our specific aim here was to reduce confusion. Can we move on to the next slide, Raisa? We're not going to have a poll. Move on to the next one. So these are some of the results from the surveys that we mentioned. And again, it ties into this idea that there was general confusion. Some people in the beginning of 2019, when the surveys were conducted, had taken measures to implement GDPR, but a very large percentage, 42%, so 2/5, had not taken any measures. And the next slide, it shows some of the reasons why they weren't taking measures at that time, that they didn't know what the requirements were. Quite a large percentage of people back at that time thought that GDPR simply didn't apply to them. And also quite a large percentage as well said that they needed more guidance. So this was also something that prompted us to work more on getting this guidance prepared. We can move on to the next slide, please, Raisa. And also, we've been looking at like the other general risk factors which apply outside our specific sector. So far I've looked at the sort of reasons why, as a sector, we became very interested in GDPR and put the project together. But also there's things happening outside the translation and interpreting sector that are very relevant here. So the number of complaints about GDPR issues has been rising constantly since 2018. The number of cases being reported to the national authorities is on the rise. The number of cases being investigated is also on the rise. There's also a rise in the number of staff working at the data protection authorities and the budget that they have to investigate GDPR issues. The Court of Justice has also had to handle quite a lot of cases relating to the interpretation of GDPR. So a lot of issues are becoming clearer or unclearer. If you consider it is clear, it clarified certain things, the Schrems judgment. Overall awareness among citizens all around Europe about GDPR and what it means for them is on the increase. And also tied into this idea of complaints and the number of cases being reported, and the number of cases being investigated, there's also a very large increase in the number of fines which are being imposed. Fines are, of course, only just one of the measures available to the data protection authorities, but it is interesting that certain activities that translators and interpreters engage in could potentially attract fines. If we look to the next slide, please, Raisa. So here we have some data about the fines. So up until September 2021, there were 845 fines imposed all around Europe. That figure is now over 900. And we did some analysis of the data, some data crunching. And in September 21, we saw that around 7.2% of the fines related to individuals. We defined individuals as freelance, not as freelance translators or interpreters, because there are no fines specifically relating to translators and interpreters, but as an individual person or a small business. And we looked at all this data and we realized that the sort of activities that were attracting fines were the sort of things that translators might do. For example, sending emails by CC in people instead of using BCC. There is a specific case about that. We don't have time to go into all those issues today, but it is one of the things that we took into consideration in this entire project and putting it together. If you can move to the next slide, please, Raisa. So one of the questions we also asked in our survey was, so what sort of information do you need? And again, this is interesting because it reflects what the European Data Protection Supervisor was telling us only a few minutes ago, that people wanted model documents, that people want clear guidelines. So in that sense, our profession is very much like other professions and other sectors out there, that there is this strong demand for more information. So again, that's what one of the things we're trying to do in this project overall. And the next slide, please, Raisa. So if I had to summarize, the general aim of this project is, and again, this ties in very nicely to what the Data Protection Supervisor was saying, that it's about safeguarding people. It's not about safeguarding the data. So we're interested in safeguarding language service providers. And you might hear this term quite a lot during the course of today's event, because it's the term that we have decided to use generally. So as a way of referring to both individual translators and interpreters, so freelancers, and language service companies, translation agencies, translation companies, because our general point of view that has emerged through discussions as part of this project is that we're all basically in the same boat. So it doesn't matter whether you are a translator or a translation agency. We need all sides to have a clear understanding of how GDPR applies to our sector. And so the aim is, in developing these guidelines and developing a code of conduct, a code of practice for our sector, is that we can safeguard language service providers. And we seek to do this by improving our understanding of GDPR, awareness of how it applies to our sector. And so in doing this, that we can actually protect data subjects and their rights and freedoms. And also because, and again, a point which was raised by the European Data Protection Supervisor, is that these issues are not just relevant in one country. There's a lot of trade and interaction across European borders. Translation cuts across boundaries and borders. And so it's important to everyone along the chain, no matter where the translator could be in one country, the translation agency in another, the client in another, so that we have a clear set of guidelines and rules and a clear understanding for everyone in that chain, so that the protection is complete all along the chain. So that's a general summary of the aim of our project. And one of the first practical steps that we did was last year, in partnership with the EU ATC, a document called Guidance on Data in Translated Content was produced, which examined, or set out our understanding of how data in the documents that we translate should be handled. It was based on in large part on the response that we provided to the European Commission, or sorry, to the European Data Protection Board when it sent out its guidance on controllers and processors. And if you haven't accessed this document, we would certainly recommend that you go and find it and read it, because it provides a lot of very sound and comprehensive advice about how you should be handling data in translated content. And then, Rice, if you could move to the last slide of the presentation. So that was the state of play up until 2021. Of course, COVID had impacted everything about the project, so there was some delay in moving the project forward. In the autumn of 2021, we eventually were able to issue a call for experts to move the project forward. And we see today the results of this call for experts. We have a very stellar team of people from all around Europe and diverse backgrounds. And we will introduce them in more detail in the next part of the conference today. So once we had selected the experts, we set up a working group. We were able, over the course of last autumn and winter, to have 4 meetings to discuss a whole series of questions which we had identified, which are very relevant to our sector and included key issues that needed clarification. And the result of this entire process of deliberation and discussion with the experts, who cover a wide and diverse number of areas, is today's conference, which is provided with the kind support of the European Commission. And as Mr. Nalepa said at the very beginning as well, this will be followed by a detailed report. So it is very true that this is just a step in the entire process of getting towards the guidelines, or the code of conduct, or the code of good practice, or whatever you want to call it. So there is more work to be done. And we are very hopeful that within the next year or so that we will have worked out or prepared the relevant code of conduct or code of good practice. And we are very happy that the European Data Protection Supervisor has declared today that the authorities at European level are very open to discussing any proposals that we might produce in order to ensure the aim of this project, which is to safeguard language service providers in their understanding and awareness of GDPR, and also then through that to safeguard the rights of data subjects. Because it is a simple fact of what we do is that as a sector, we process huge amounts of data on a day-to-day basis. So these guidelines, this project, are all essential and vital. So that's my basic introduction to the project. And we're going to move on now to the first panel discussion of the day.
Many thanks, John. Can I just interject there? There's a couple of questions that we'll briefly just comment on before we move on. Stephen is asking about a link to the EU ATC guidance document. I don't have it just now, but I'll dig it out just with a note to say that it does date from last year, so it hasn't yet been updated with the latest information on new standard contractual clauses and so on, published last year. So that document will be updated with the results of what we found through this GDPR project, and with latest documentation and regulations from the EU as well. So when you read it, just keep that in mind, but I'll post a link here. There's also a question from David on email marketing and so on. And I just wanted to mention here that this TEW GDPR project that we're doing together with European colleagues and collaborators, it is only aimed at figuring out specifics for the translation and interpreting sectors. So for translators, interpreters, language service companies, everyone involved in that process. So what we aren't looking at are GDPR related dilemmas and questions around doing business, because that's common for all small, medium, large size businesses, and there is lots of information around that, albeit of course lots of confusion as well. But because we're the only ones who are able to provide the expertise for our sector, this is the focus that we must take here. So we're excluding everything that just relates to normal running business, including marketing and so on. Okay, I'm just going to flip over my slides and back over to John.
Okay, so now is the point in the day where we can actually introduce you to our team of experts. So we have, I'm going to quickly run through the names and then everyone introduce themselves and explain how their background a little bit and how they are involved in translation and interpreting and their involvement in GDPR as well. So we have Professor Małgorzata Dymkiewicz from Poland. We have Melina Skondra from Greece. We have Manuel Herrands from Spain. Stephanie Bogerts she's from the Netherlands, but lives in Poland. Unfortunately, she can't be here today, as we said. We have Pablo Motsky. We have Zoe Milak. We have Wojciech Wowoczyk and Raisa Magnab, who is in Finland. So we have a quite diverse team of people from a lot of European countries here, because we thought it was also very important in preparing this project that we have a geographical spread from different parts of Europe, so that different perspectives and different points of view were brought into consideration in the project. So if we can go through the speakers then in the order in which they appear on the screen, they can introduce themselves. So over to you, Małgorzata.
Good morning, everyone. My name is Małgorzata Dymkiewicz. I am academic teacher at the chair of commercial law at the university in Lublin. I am also a professional legal advisor in Poland. And personal data protection is one of the fields of my scientific as well as professional interests. So my contribution to your discussion, to your issues will be in the aspect of legal basis and legal regulations for protection of personal data in this translating and interpreting fashion industry. Thank you very much.
And Melina.
Good morning to all. I'm very pleased to be here with you all today. Thank you, PITS Europe and European Commission for having me in this experts group. My name is Melina Skondra. I'm a lawyer from Greece, and I am a GDPR expert, if I may so say. I am a certified information privacy professional by the International Association of Privacy Professionals. And for the next 2 years, I also have the honor to have been appointed by the IAPP to co-chair the Greek chapter of the organization in Greece. I'm also a member of the scientific research group in IT law in the Applied Informatics School of the University of Macedonia in Greece. I've been familiar with GDPR compliance in the T&I sector since I had the chance to present also a webinar for the Greek Association of Translation of Translators in the past, and to identify the main issues in the sector and the issues and challenges the sector has to face, the problems it has to surpass in order to comply with this regulation. I've been in charge of many GDPR compliance projects in Greece and in different types of businesses and sectors. And what I can say is that the T&I sector encounters some challenges that other sectors do not have. I was really impressed by the high level of awareness and understanding the sector had in the GDPR, which was much higher than in any other sector I knew. But we will talk about all that later on. I'm really honored to be part of this expert group for Fit Europe, and I hope to be able to contribute to the compliance of the sector to this very important regulation of the EU. Thank you.
Thank you very much, Melina. Manuel.
Hi, hi, John. Hello, everybody. My name is Manuel Herrands. I'm CEO at Pangianic. We are in the group representing a developer of anonymization solutions. We led a successful anonymization project called MAPA. That's multilingual anonymization for public administrations, of which I will speak more later. And I'm here in the group as the solution provider, or at least the person that builds on the technology solution that can be applied at institutions and corporations and companies. So I'm aware, my team is aware of the nuances and the intricacies of anonymization in different languages, how easy or difficult it is, what different applications or different deployments represents as challenges. It's not the same to try to anonymize text within a translation tool, or to anonymize text that comes from some legal proceedings and is fully multilingual and has no images, for example, or databases, PowerPoints, or format-rich text. So, well, I look forward to my presentation later on and running a little demo.
Thank you very much, Manuel. Pavel?
Thank you, John. My name is Pablo Motsky, and I hold a PhD in IT law from Paris and Münster. I also hold a degree in linguistics, which has allowed me to work as a legal expert in the Institute for the German Language in Mannheim. So I am a lawyer specialized in legal issues in all sorts of language technologies, with a particular focus on machine translation. I also serve as the chair of the CLARIN Legal and Ethical Issues Committee. CLARIN is a European infrastructure for sharing language resources and language technology. I am also certified to practice as an attorney in France, where I live most of the time. And yes, well, thank you for having me here, and I am very much looking forward to the discussion that will certainly be very interesting. Thank you.
Thank you very much, Pavel. Zoe?
Hi there. My name is Zoe Milak, and I'm a staff translator for Banca d'Italia, which is Italy's central bank and a member of the Eurosystem. In addition to that, I have a legal background and 20 plus or so years of experience as a freelance translator, an institutional translator, and working in translation agencies. So I've seen a bit of every part of the industry. Obviously, for Banca d'Italia, data protection in general is of major concern. And in the last 3 years, of course, there has been a staff dedicated to GDPR compliance. So I'd also kind of like to thank my colleagues there for sort of their input on this topic and giving me some background on it from an institutional standpoint. And I'd like to thank, John and the rest of you for inviting me to be here today. Thanks.
Thank you very much, Zoe. Wojciech?
Hello, everybody. My name is Wojciech Wołoszyk. I come from Poland. I'm a lawyer linguist with a strong background in EU translations. I'm also CEO of Juridico Legal and Financial Translations, which is a provider of legal translations for EU institutions and international courts. I'm also a member of board of TEPIS, Specialized and Sworn Translators Society from Poland, and member of board of POLOT, which is Association of Polish Language Service Providers. My academic interests focus on machine translation in the legal sector and public administration, and good practices on using properly such solutions in the legal and language industry. I hope to have interesting and fruitful discussion today. Thank you.
Thank you very much, Wojciech. And Raisa, could you say a few words about yourself?
Thanks, John. My name is Raisa McNabb. I am translator by training, Finnish with French and English, but my career has been spent in the language services industry in a language service company, and I now work as CEO at the UK's Association of Translation Companies. But today I represent European language service companies as the EU, the European Union of Associations of Translation Companies, the EUATC's GDPR representative. I'm the author of the aforementioned GDPR and personal data and content for translation guide for the EUATC, and I will also be updating that later on. I don't have a legal background, which is why I'm so glad we have so many legal experts here. It has led to some really, really interesting discussions. My angle into this project and my expertise is in the practical application of GDPR at language service providers, whether it's freelancers or language service companies. And I'm especially interested in the element of how we can mitigate the risks around GDPR implementation, the risks to the rights and freedoms of data subjects. So that's my angle on here. And maybe John, you can now introduce yourself as well.
Yeah, and I am John O'Shea. I am the recently elected chairperson of Fit Europe, and I previously served on the board of Fit Europe as a board member. In my professional career, I am a legal translator from Greek to English. I've been doing that for about 25 years or so. And prior to that, I used to teach European and environmental law. So I also have a legal background. And I'm very glad that we have been able to put together this team. So what we've been talking about so far this morning is the need for more awareness in our sector about GDPR, and also awareness of the risks which arise, and also the bad practices which exist out there that need to be changed and addressed. But a sort of very general question, possibly to one of our lawyers, maybe to Pavel or to Melina. Could you explain to our audience today why it is so important to be compliant, or to try to be compliant with the GDPR? Who would like to take the question? Pavel, maybe first, then Melina.
All right. Well, I think complying with the law is a value in and of itself. I think according to the view on law and society, which is my view, respecting the law is part of being a good, respectable citizen, which is in itself a value. And I think that this is why most people actually follow the law. But we can also take a less idealistic view, a more pragmatic view, if you will, and say that it is worth complying with the law is worthwhile because it allows to avoid sanctions. And there are considerable sanctions in the GDPR. I don't think we should spend too much time talking about them, because our purpose here is not fear-mongering, but rather discussing the practical ways to become compliant in a way that does not harm translators' daily activities or impact them in a way that would be seen as too severe. So I don't think we should concentrate on sanctions. So let me take this idealistic view. It is worth complying with the GDPR because, well, if you comply with the law, you are a good citizen, an honorable citizen. So in itself, this is a value worth aspiring to and achieving. I wonder what's Melina's view on that question.
I would only add to what Pavel said, that it is of critical importance to comply with the GDPR, because the GDPR was put in place in order to protect a vital fundamental right, which is data protection. Data protection in the EU is a fundamental human right, as you may know. So complying with the GDPR means respecting fundamental human right. I don't think that I would have anything more to add to that. I think the IDP, Mr. Dvorowski already answered the why on this question. And I think also that complying with any legislation, since we are conducting a business, makes us more more competitive towards our clients, because as awareness is growing continuously around Europe on the data protection, data subjects are expecting every businessman and every organization to respect its privacy and its right. So it is going to select between different companies or organizations, the ones that do respect its rights.
Thank you very much for that, Melina. So that brings me to the next question. So you mentioned again the European Data Protection Supervisor, and he mentioned about this idea of principles, and one of the ones he mentioned was accountability. So could you or Pavel, as our legal experts, talk about what you think are the most important data protection principles for the translation and interpreting sector that we need to bear in mind?
Yes, John. Well, one of the nice things about the way that the GDPR is drafted is that it contains a list of rather clear general principles of data protection. And I think that if there is only one article of the GDPR that you can read in your life, then make it Article 5, the one with the list of data protection principles. Of course, all those principles are equally important, but if you ask me which are the most relevant for translators, I would say, well, there is a number of them. There are several such principles that are in danger of being overlooked in the work of a translator. One of those principles is transparency. It's a principle that says that the data subject, that is the person that the data refer to, should be informed in a transparent way, in a clear way, about various aspects regarding the processing of his or her data. On a more, even more practical note, there is the principle of storage limitation that, to put it simply, says that one cannot keep personal data indefinitely. Personal data can only be stored, kept for as long as necessary to achieve the purposes for which the data are being processed. So if you no longer need the data, then the data should be deleted or anonymized. A principle that is closely related to storage limitation is the principle of data minimization. That says that one should not collect and process and store, including more data than necessary to achieve the purposes. And this has very practical application in the translation sector. So if you are approached by a client and of course you need the data you need the client's data, you need the client's information, his, well, you may need his email address, depending on the circumstances, you may need his postal address to be able to bill your services to the client, but you should not collect more than what's strictly necessary for you to receive the payment for the services. So for instance, collecting the client's date of birth or place of birth would be excessive from the point of view of the purpose of getting paid for the translation service. There's also the principle of data security, which says that the data should be kept safe and there should be organizational and technical measures put in place to make sure that the data, personal data, are protected against, for example, unauthorized access or accidental deletion. So keeping your client's data at a USB stick or an SD card that you just throw in your pocket might not be safe enough to comply with the GDPR. You really have to think about organizational and technical measures that would keep the data safe. And finally, there is a principle that kind of, it's like in Lord of the Rings, one to rule them all. And I think that the accountability principle is the one to rule them all. This accountability principle says that the data controller is the one who is responsible for ensuring and demonstrating compliance with the GDPR. From the practical standpoint, it means that every GDPR-related decision should be documented in case of an audit by a data protection authority. So whenever you are the controller for the processing and you make a decision that would impact the processing, for instance, you define the retention period, the duration for which you will store the data, or you define the organizational and technical measures to keep the data safe, these decisions should be documented so that you can prove in case of an audit and in case of control that, well, you can prove that these measures have indeed been implemented. So yeah, these are the principles that I think are among, these are not all the principles of the GDPR, but I think that these are the principles that are among the most important ones, unless anyone wants to add anything to that list.
Melina, I can see Melina wants to speak.
Yes, I would only add to all that Paul said, the principle of lawfulness that obliges us to always identify and find the appropriate legal basis for our processing. So we are not to process any data unless we primarily have identified the appropriate legal basis to do so. And we will talk about all this later on. So that's the only thing I would like to add at this point.
Okay, thank you very much for that, Melina. And Zoe, I have a question for you now because of your extensive experience in different aspects of the translation and interpreting sector. So we've talked about the principles and we've heard a lot already, that this is all about data. What sort of data are we talking about here in reality?
Well, I mean, first of all, I think we should just briefly, as we've made reference to, describe the supply chain for a translation project, which very simply, the most simple way is that a client brings a document to a language service provider, which can be, as you said, an agency or a human freelance translator, to have a document translated. And the supply chain can be long or short. So it can be the direct contact between the client and the translator who does the translation, or you can have the agency in the middle who subcontracts it out to another language service provider, a freelancer. So where an LSP falls along the supply chain can be a factor in determining what its obligations are under the GDPR. And another factor is sort of the data itself that's being processed. And I think we should again reiterate that we're talking about personal data and not just data confidentiality as a general concept. So what kind of personal data are we as translators likely to encounter that would bring us under the umbrella of the GDPR? And basically there are two categories, which would be administrative data and the personal data that would be contained in documents that we translate. And administrative data would be just like the data that the LSP would collect from its client to perform its business functions, to invoice or to project tracking or preparing contracts and such. And examples of these would be, getting your client's name, address, taxpayer identification number. It could also include, if you're dealing with, your client is a company, for example, employee, the contact information of the employee that you have to deal with. But there's some subtleties to that maybe we should put aside for now. The other kind of data is sort of that contained in the document itself that we translate, which would be like medical records, an obvious one, which also has special protection under the GDPR. Birth certificates, death certificates, also legal documents would contain reference to identifying information on data subjects. So sort of putting these two factors together, supply chain and data type, will kind of help us determine what an LSP's obligations are under the GDPR.
Okay, and can you, on a related point, I think of any situations where there might not be data in documents at all? Or
well, for example, I think that's many of the translations that we do. Again, we're talking about personal data. So we might, that's why I specified something like a birth certificate, because that is very obviously personal data. It has the name, it has the, if you have a social security number or whatever it might be called in your particular jurisdiction, address, your parents' names, everything that will allow someone who has access to the document to identify you. But, if someone were to come in and they just want to translate, a poem or something, that's not the kind of data that we're talking about that has to be protected because it doesn't identify a data subject. So we have to sort of be very, again, it's not just respecting our clients' confidentiality in general, but very specifically data that identifies a person.
Yeah, one other thing that immediately jumps out to me as well is like technical manuals would not have personal data in them typically, and again that accounts for maybe quite a large proportion of what it gets translated, and so GDPR would not be relevant to that particular aspect, but it would be relevant to the administrative data mentioned. Okay, thank you for that clarification, Zoe. If I could ask a question now to Wojtek. So we've talked a little bit now about the general principles and about the type of data, but then what are we doing with the data? So how are we processing? How are we handling it? What does the GDPR say about that, and how is that relevant to our sector, to the TNI sector?
Yeah, thank you for the question. It complements to some extent answer given by Zoe. First of all, we are processing data of our clients. It's a kind of administrative processing data which are processed in the context of standard business activities, which are not specific only for translation and interpretation sector. This is in purpose to identify clients, to communicate with them, send quotes, accept jobs, issue invoices, and perform some promotional and advertising activities. So this is a type of processing of data which is common for all business sectors. but we also process data of persons, data subjects who are part of our supply chain. I mean here, data of our suppliers, mainly our subcontracted LSPs, smaller agencies or specialized agencies or individual translators who are working for us, and we are processing their data, storing their names, their contact details, processing them, keeping them in our databases. So these are not very specific and limited only to this kind of data processing is not specific and limited to translation and interpretation industry, but there is a kind of specificity in this type of processing data because of the very long supply chain. Very often it's in a lot of cases it's even untraceable. The first client who gets assignment from the end client, which is a big agency, can even doesn't know who will be the final contractor, the final person or entity doing the translation, which is not a very good solution in context of GDPR compliance, but this is our reality. So we have to take that perspective into account, also working on our guidelines. And the most specific type of data processing which we have to deal with on a daily basis in our industry is the processing data contained in the translated content, meaning in written documents, in recordings, and this is the most typical and specific for our daily business. And in this context, we process data for the need for the purpose of doing the translation, for preparing translation memories, for managing, for storing, for aligning parallel texts, for reusing data for another assignments. And the very interesting case of processing data is the interpreting services, which as such is not a part of processing personal data, as long as the interpretation is being recorded, and this produces some additional issues we have to discuss, we have to think over regarding who is responsible for recording, who keeps, who stores the recording, and then whose role is being the controller and processor. In this case, interpreters should be very careful for recording interpretations for their own purposes, and also in case of dealing with some reference materials when preparing for providing interpretation services. In that case, they should also bear in mind that they should receive consents from and sign necessary agreements with their clients. So that's all. Thank you.
Okay, thank you very much for that. So you mentioned when you were talking there about roles. So if I could maybe go back to Zoe, and also this is something that ties into what the European Data Protection Supervisor was saying this morning about the importance of identifying the roles, and it's one of the key things that we've identified as being problematic. So are we controllers or are we processors? And you answered that pretty cool question.
Well, I think this kind of also goes back to the idea of the supply chain. And the GDPR defines a data controller as a natural legal person or public authority, agency, or other body which, alone or jointly with others, determines the purpose and the means of the processing of the data, of personal data. And the key words here are purpose and means. So, what are our purpose and means? And essentially, our purpose is sort of, why are we processing this data? Why are we doing this translation? And the means refers to kind of the how is this work being done? And as we saw, the one who decides these two questions is classified as the data controller. Instead, the data processor is the one who processes the data on behalf of the data controller. So the data processor follows the instructions of the data controller on how to process the data. So kind of going back to the idea that we were talking about, the different types of data, how do these two roles relate to the type of data? And we said before that for administrative data, as we said, sort of like in the because it relates sort of to like the internal business processes. In that case, the LSP would be the data controller. And why is that? Because the LSP is collecting data from its client, on the client, or if you're talking about a freelancer, on the translation agency that engaged it to do the translation for its own business related functions like invoicing and such. So the name, the address, etc. So in this case, the LSP, first of all, is it deciding on the purpose? Yes, it's deciding why it needs this data. And that's for, to carry out its administrative tasks connected to managing the account. And is it deciding on the means? Well, basically, it's deciding how it's going to use that data to prepare the invoice or make entries in its records or such. And so I said, going back to the supply chain, in effect, let's say you have the client at the top of the supply chain, and you might have an agency, and then you have a freelance translator below. Well, the freelance translator, even though it's sort of at the bottom of this chain, is still the data controller with respect to the ring right above it, which would be the agency, which then, of course, it's a data controller to the ring above that, the client, as far as administrative data goes, because it is collecting it for its own business purposes and is processing it for those purposes. So, as far as however the data in the documents themselves to be translated goes, the situation is almost, it is the reverse, basically. It's the client who comes, who has a reason. So it has a purpose for this document that is being translated. And it decides on the means, which is namely hiring an LSP, person, agency, whatever, to translate the document. But this kind of raises the question is, what exactly does means mean in this kind of a situation? Because, other than saying that I want a document translated from, language A to language B, does a client generally really know what the process of translation entails? They could, or they might just go to a translation agency or an LSP as a professional and entrust in the professional has the technical know-how to do a translation. So it doesn't need to know the details, but it knows that it's entrusting its job to this professional. So in this case, what does means mean? Well, it seems that the guidelines in the GDPR leave us a little bit of flexibility here, making a distinction between what's an essential mean and what's not essential. And an essential mean is essentially in this supply chain that we discussed is the client has decided that it's going to engage a professional to provide a service to the client. Non-essential, those are essential. Those are those that are means that are left to the discretion of the professional that's engaged. Because, like, so for example, the software that a translator might use, the CAT tools, a dictionary, or such. And I think we'll also be talking about sub-processing later. So, does this rise to the level of the means? And generally we would say, no, it doesn't, because we're talking about just merely the technical aspects of performing the work and not the overarching means, which is decided by the data controller, who has decided to engage a professional to provide the service to him or her or it, which is exactly why one would hire a professional in the first place, because you don't have that expertise. So in this relationship, again, the client is the controller because it has decided the purpose, it's decided the why, it's decided the how. I'm going to get a professional to do this job for me. But the professional who has that technical expertise is the one that then decides sort of the minutia of how the product is going to be generated.
Okay, thank you very, very much for that. And on a somewhat similar or related point, Raisa, so we heard a little bit about like what the processing that happens. So what if the LSP in our situation here decides that he wants to do something else with data, to process it, like maybe to take all this data that is already in his or her possession and to use it to train a machine engine or something like that, or to use it in a translation memory or something like that. So do you have anything to say about that?
This is one of the key questions that we have in the industry, because of course we know that translation memories, the data that we've translated is one of our biggest assets. So we'll talk a little bit more about this in the afternoon session. But fundamentally, and we've already heard that from Mr. Wiewierowski this morning, that there is a real risk that the processor, the LSP or the sub-processor, whoever they subcontract to do the work, turns from a processor or a sub-processor to a controller, because they're taking the data provided by the controller and doing something different with it. And I think here we have one of the biggest clashes, the biggest gray areas that we haven't yet addressed as an industry, to say, okay, what can we do with our translation memories? How should we approach this issue? What do we do with legacy content and so on? These are some of the questions that we'll come back to with our legal experts this afternoon. Fundamentally, I think we have some hard decisions to make about our data for us to say, actually, what do we need to do in order to comply with GDPR here? I think fundamentally, one of the key elements in everything that we do is to try and figure out what kind of processes can we put in place to mitigate the risk or minimize the risk, or remove the personal data. Because although we talk about all these sorts of complexities around roles and what do we do with content for translation and so on, fundamentally, if there is no personal data in the content that we translate, there is no GDPR liability. So what can we do in order to remove that liability so that we have got data that we can do something more with? But join us this afternoon to go a little bit into more detail about all of that.
Thanks, Raisa. And Pavel, I saw that you had raised your hand. Did you want to say something?
Yes, I mean, in my experience, when we start talking about controllers and processors, and we start using these two words in one sentence very close to each other, the lay audience tends to get lost. And I think it's worth spending an extra minute to make sure that to get these things straight and make sure that our audience is following us. This terminology in English, especially for non-native speakers, might be slightly counterintuitive. So the controller is the one who is defining the means and purposes of the processing, at least the essential means and purposes of the processing. And he's really responsible for GDPR compliance. It's worth noting that in French or in German, the controller is actually called the responsible one, the person who bears the responsibility for the processing, le responsable du traitement. And I think it's important to bear this in mind. Controller is responsible. The processor, however, is processing data on behalf of the controller, and in the French terminology, this role is called sous-traitant, which translates directly as subcontractor. So the controller. So because I'm seeing the chat and I see the questions, it's also that these two roles, when they're not assigned permanently, once you are the controller for one processing, you'll be the controller forever for all processings. It does not work like that. It depends on the processing. So the translator or the LSP is actually performing in its daily practice several types of processing operations, and it's important to distinguish at least between two fundamental types, which is the processing, the actual translation, that is processing of the data in the translated document. And for this processing, we believe that, at least in general, the client is the controller, and the LSP, the translator, is the processor. But for another type of data processing, that is the processing of administrative data, the data that we call administrative data in this project, but these are the data necessary for invoicing, for example, or complying with legal obligations. For this type of data, the LSP, the translator, is the controller, and then you can have processors, of course. But and I think that this distinction is really fundamental. I haven't added anything new to what has already been said. I just wanted to take a minute to make sure that the audience is with us.
Thank you very, very much for that, Pavel. And it also ties in quite nicely into the next question that I wanted to ask anyhow. So we're talking about controllers and processors, but what are the standard obligations which apply to controllers? Maybe Melina, you could talk us through that.
Yes, I think that there is no difference with other businesses and sectors as far as administrative data is concerned on our obligations as data controllers. Our main obligations is to comply with the general principles of the GDPR that we earlier mentioned. And what does that mean in practice? That means that when I'm a controller, I must comply with, for example, transparency, the principle of transparency, meaning I should have in place a written privacy notice to hand to my data subjects or to publish it online, perhaps. In this privacy notice, I should be very transparent on why am I going to process their data, on what legal basis am I going to rely on how long my processing is going to last, on who the recipients of the data might be, etc., on the rights the data subjects have about their data, etc., etc. This is a vital obligation of every controller. So, first one, privacy notice to comply with transparency principle. I earlier mentioned the legal basis. When we are controllers, we decide on the why and the how, as Zoe said, of the processing. That means that we are responsible for choosing and identifying which is the appropriate legal basis for every different processing operation we are going to do. So, for example, a legal basis, first of all, I should say that the GDPR provides for 6 specific legal bases. Those are consent, performance of a contract, legal obligation, vital interests of a natural person, public interest, which does not apply on us, and finally, legitimate interests. So any of the five, because I will not include the public interest in our case, any of the rest, five other legal bases could be applicable for our processing, but we should choose the right one for which processing. We usually will rely on the second one, on the performance of a contract, as far as administrative client data is concerned. That means that we should collect our client's name, his telephone number, his email address, in order to be able to perform the contract we have in place with him. But that does not cover the case when we have to collect his VAT number, for example, which is necessary for us to issue an invoice on him. So on that one, we should rely on our legal obligation, that because we have a legal obligation to issue an invoice. Another usual legal basis we could rely on in some cases is legitimate interests of ours. For example, when we have a monitoring system in our premises for the security of our premises, we cannot rely on any other legal basis than in legitimate interests. But we should stress out that this legal basis is not very clear, because it requires us to primarily conduct an assessment, a legitimate interest assessment, on whether our interests are overridden by the interests and rights of the data subject. So we could not use such a legal basis where the processing might be a little bit intrusive on the data subject. And last but not least, there is consent, which is a very difficult legal basis, because consent is freely revocable. So at any time, the data subject could decide to revoke the consent it gave us, and that would leave us with no legal basis from then on. And also because consent, we do not usually advise to use this legal basis unless there is no other applicable, because the consent, in order to be valid, must meet some conditions. It should be specified. So we should ask for a granular consent of each processing we want to undergo, and it should be freely given, and it should be informed. So freely given would exclude using consent, would almost always exclude using consent as a legal basis for example, processing employee data when we are the employer, because usually the employee is not in a position to deny to give us its consent. The ADBB has stressed out that where situations with power imbalance are involved, we could not consider the consent to be freely given, so it would be not valid. And also, sorry, my fault. So another obligation we have is to keep a record of processing activities in some cases. It is an instrument and a tool that would help us very much in knowing what data we have, what data we process, and for which reason, and for how long, and what measures we could take about each data set. And another obligation I think is vital also is to decide and even document and write down a schedule on our retention period of any different data set we process, so that we could keep up with our legal obligations, because perhaps There are different national laws that apply on data retention periods. For example, in Greece, we are obliged to keep invoices and tax data for at least 10 years and to not delete them or destroy them earlier than that. So in my retention schedule, I would have tax data to keep them for 10 years and not more. And even if there is not a national law that says what to do and how long to keep any different data set, then we should go back to the general principles and follow the storage limitation principle, which obliges us to not keep data for more than it is absolutely necessary for the purpose for which they were initially collected. We should also prepare a procedure, a written procedure on what we should do when we receive a data subject request. For example, data subject decides to exercise his access request. We should be ready to answer this request within 30 days. So we should have in place a procedure that would lead us step by step to what we should do when we receive such a request. The first thing, for example, that we should do is identify that this person is really a data subject of ours, that we do have its data. The second step might be find the relevant data of this person, etc., etc. And it would help us very much to comply with our obligation to satisfy within this time frame of 30 days to our data subject requests. And I should not, I should also mention that another written procedure I think is vital to have written down is a procedure on data breach incidents. We should have in place a procedure that would lead us to what we will do when, if and when we are encountered with a data breach. Such a processing might, for example, mention that the first thing to do is to see whether these data are personal or not, is personal or not. If it is, what to do. If it is, the GDPR says that we should notify the local data protection authority within 72 hours unless there is no risk for the data subjects at all. Even if there is even a low risk, then we are obliged to notify the local authority. And if the risk is high, we should notify also the data subject so that they can take some measures to mitigate those risks. We could not do all that after the incident occurs. So we must be ready to respond to such an incident from the beginning. So I think that having such a procedure is fundamental for our compliance. Another thing that we should do is to have in place data processing agreements with our subcontractors and our sub-processors or processors. That is an obligation that the GDPR imposes on both controllers and processors when they have sub-processors. So if some of our subcontractors are not willing to sign such a contract, simply we must change supplier or a subcontractor. Because if we do not have such a processing in place, then we infringe Article 28 of the GDPR. The same applies for our employees when we have such category. If we have employees where we are responsible for their actions, and the GDPR says that we should have in place also confidentiality agreements signed by them. And last but not least, at all times, we should take every appropriate technical and organizational measure in order to keep the data safe, available, and intact.
Thank you very much.
The measures we are expected to select and put in place are the measures that are appropriate for our specific processing. Where there is a high risk in the processing, the measures should be stricter. Where the risk is lower, the measures could be less strict, for example.
Thank you very much, Melinda, for your very comprehensive answer. So we basically talked there about the situation which applies for controllers. Małgorzata, could you run us through very quickly the legal basis for processing when you're a processor, and maybe talk a little bit as well about the data processing agreements which Melina referred to?
Yes, I will try. So the main thing, so firstly, we have to mention that the processor derives its legal basis for the processing of personal data from the controller. So he has not his own purpose in processing the data. And that is why he must act within the scope defined strictly by the controller. And the legal instrument for this, for the ordering this process is called data protection agreement, the data processing agreement. And this concluded between controller and processor. So in our field, it is between LSP and between his client. And this agreement sets out the main obligations, as well as subject matter, as well as duration of the processing of the data, the nature of this processing, and the categories of data which are to be processed. So this agreement should be written down, because GDPR imposes a demand that it should be in writing, including in electronic form. So it means that the main provisions of the agreement should be written down, but the manner of recording can be both in paper or in electronic form. So it is not necessary to be written in paper, yeah, in this traditional form. Of course, there is no definition of electronic form in EU law, but we have definition of electronic signature. But it is not very clear if we have to sign this document, which we conclude in electronic form, in one of specific types of electronic signatures, because we have in European Union advanced electronic signatures and let's call it not advanced, so other electronic signatures. And there are no strict rules that we have to sign this document in one of these advanced electronic forms. So we can assume that any form of writing it down in electronic form is sufficient. But the most obvious requirement from the Article 28 is that we have to conclude this agreement before we start processing data which we obtain from our client. And the main conclusion, the main consequence of that agreement is that after we conclude it and we obtain the data, we have to process the data only on documented instructions from the controller. So we have to bear in mind that it is our to be on the safe side, we have to have some documentation of these instructions. So if we just want to translate it and send it back to our client, who is controller in that case, we should try to take from him instructions on in which way we have to submit him translation. It should be his decision. So if we have to send it via electronic mail, email, or in writing, in paper, it should be his decision. So we have to be on the safe side. We have to have documented instructions from the controller. Other obligations, other standard obligations which should be set out in the agreement is that we have to ensure that any person from our staff authorized to process the personal data obtained from the client have committed themselves, as Melina said, to confidentiality or are under appropriate statutory obligation. Because it can be that in some member states we have such sworn translation acts that stipulate such obligations as legal obligations directly from the act. Yes, so we should bear it in mind. Then, which Melina is already mentioned, the obligation of implementing such organizational and technical measures which are appropriate to ensure security level appropriate to the risk of data processing. So in this obligation, we are on the same side as controller. So there is no difference. As well as controller, we have, as a processor, we have to secure this level of protection. Then we have to bear in mind that the very important obligation is that connected with the conclusion, with the finishing of the process of translating, because this contract should stipulate, should set out that after we finish our data processing, our service connected with data processing, on the choice of the controller, we have to delete or return all the personal data to the controller, this purpose of processing, which is determined by the controller, is strictly connected with the time, with the duration of the processing. So we cannot exceed in the agreement this purpose. Because purpose is strictly connected with duration. It means that duration is governed by purpose. So if we definitely finish our services, so our translation is accepted and we submit it and it is accepted, not any amendments are not necessary, it means that the purpose is finished, is obtained, and further processing of the data means that we are turning into controller with all consequences that Melina had already mentioned, has already mentioned. So these are the basic obligations, and the list of provisions which are necessary in the agreement is in Article 28. Yes, we have this list very specific. So that's are the main.
Okay, and what about then in relation the idea of standard contractual clauses? How does that relate to data processing agreements and these standard obligations?
So we have this document which allows us to use standard obligations, but it means that we it's a regulation, so you have probably well, it's a EU regulation on standard contractual clauses, and it means that if you choose that way, you sign your data as a processor and your client as a controller, and you are obliged to use all these standard contractual clauses which our European Union legislator stated, and that means that you cannot change them. And this standard contractual clauses somehow can be adapted. I mean, only in this form that you can fill in the gaps. But
and the
other
annexes.
obligations, yes, so duration, purpose, category of data. So this is to be filled in. But other obligations are just as they are set out in this document. So
okay, so it's another way of doing it, but it's more set in stone.
But maybe you can just treat it as a as something that you can put into your own agreement, and you be more elastic with this with provisions. So,
and also, like on the related point, then, so what happens if the controller is not giving you a data processing agreement to sign?
So you should, it is advisable, you should have your own draft of such an agreement to take to give to the controller to sign it up. Yes. So.
And what happens if they refuse?
Yeah, of course.
Yes, but what happens if the controller refuses to sign the data protection agreement?
Okay, if he refuses, you cannot process the data, personal data. So you can ask him to anonymize data in this content, and then send you the the text, which are from which this data were removed.
Okay, thank you very much. So on some more related questions about these data processing agreements obligations. Maybe we switch now to Wojtek and or Zoe. A lot of times we see in data protection agreements that come from, say, translation agencies where they want to audit a freelance translator about compliance with GDPR. Zoe, maybe you could say something about that.
Well, as processors, we are, as we said, obliged to assist the controller, in fulfilling its obligations. But it's obviously to our benefit to try to construe it as narrowly as possible. Just try to find the balance between assisting while protecting the confidentiality of all of our other information, all of our other files and such. So yes, we should, in the DPA or in some other agreement with the DPA, specify precisely what data is subject to this audit, what we need to protect, how we're going to demonstrate or to sufficiently for the data controller that, or if we are the controller, to the client or the authority, that the personal data being processed is being processed and protected properly. And we should also specify, to the extent that we possibly can negotiate, is the audit going to be conducted remotely, giving them access to our computer, for example, or our cloud or whatever? Or is someone going to physically come onto the premises and look through the files, look through our computer files and such? So we have to really, as professionals, try to limit access as much as possible that is not, but nonetheless remain compatible with conducting an audit. So as I said, narrow as possible in contract, have it written down, specify what we have to do, what our obligations are, what kind of files that we're going to need to produce, maybe how we're going to keep those files and such, so that we can sort of easily extract that data or demonstrate how we've protected that data in the data storage record keeping for that very specific client and the data that pertains to the data subject for that project, and sort of try to wall it off from the rest of our data. So that can be technological and, again, get it all in writing to the extent possible.
Okay, thank you. And Wojtek, so if we have signed a data protection agreement with a controller, are we as translators able to use sub-processors to get someone else to do the translation for us, say? Because you talked earlier on about chains or in the sector.
And so once again, this is quite a tricky and problematic issue in our sector. According to earlier interpretation of general permission concept it was accepted that on the basis of such general permission, it's allowed to use defined categories of subprocessors in general without listing them by name in the DPA. However, this interpretation changed, and to strictly follow our rules of GDPR, we are obliged to include in the agreement the full list of subprocessors. It means all the service providers, subcontractors, translators, reviewers, providers of any software, machine translation, CAT tools, accountants, and everything. So it's problematic for all kind of business, but especially in the case of translation sector, where the chain supply is quite long and quite hard to trace. It means that it's not even feasible to provide the full and complete list of subprocessors, but in accordance with GDPR requirements, it has to be done. So this is issue which requires further research and discussion and guidelines. It is also problematic from the competition and confidentiality point of view, problematic because we, as a provider of translation service, giving full list of our subcontractors and translators this is in contrary to our own interest, because we provide our client with the know-how, with data of our staff, of our translators, our reviewers, who we rely on, and it can also mean that, of course, we can sign additional agreements, but we know from a daily practice that providing too much details to our client is not in our interest. So the other problem is that the list of possible subcontractors is in translation industry is quite flexible and fluctuating because of also availability of translators, who are in most cases freelancers. Today they are available, other day they are not, and providing and fulfilling translation projects using in-house team is not something which is quite typical for the industry. In most cases, we are using freelance translators, so the list of subprocessors changes from day to day, and it's not possible, it's not feasible to provide our clients with the full database of names of our translators and reviewers. So this is problematic and tricky, and requires further research and analysis.
Thank you very, very much for that. So we're quickly running out of time. So a lot of the very important or really tricky issues, like the one Wojtek just referred to, like data retention or possibly the use of online tools and things like that, we will be addressing later in the day. So we will not talk about those now, but it is interesting to point out that, yes, there are a certain category of questions which have quite clear-cut answers, like the role of us as processors when we're dealing with the data in translated content. And then there are this category of areas where are still grey, where more guidelines need to be worked out, and we don't have all the answers. So I think we have a couple of more minutes left, so we can take a couple of questions. And I see from the chat, there's a question from that Pavel wanted to answer. that if we say the client is the controller, should we differentiate based on client type? Pavel, would you like to address that particular question?
Yes, thank you. So your question, I mean, Maria who asked that question, and it's a very good question. It refers to a situation where the client is a private individual, and we would have this feeling, this kind of ethical intuition, so to say, that in this kind of situation and dealing with the private individual is the professional who should assume the responsibilities. So the translator should assume the responsibilities. And this is why Maria, who asked the question, suggests that in such a situation, the translator should become the controller. This, however, is not the case. The GDPR applies to all controllers equally, regardless of their status, their experience. There is this principle formulated by the ancient Romans already that some theoreticians call the eminent principle, ignorantia juris neminem excusat. So the ignoring of the law is not an excuse for anyone. So even if your client is a private individual, he is still the controller for the documents that he brings you, and you are still the processor. There are, however, some pitfalls in this kind of situation. So the first one is what happens if the client is and his processing is covered by what's called the household exemption. So there is an exemption in the GDPR that says that purely domestic and household activities are not covered by the GDPR. And the traditional example is, for instance, having a notebook with addresses and phone numbers. Now we also mention posting on social media in such a way that only your close friends can consult the content that you posted. This is covered by the household exemption, and such processing is not covered by the GDPR. Does it apply in the translation context? I think that the cases where this would apply would be really extremely rare. For example, if you are translating, if a client is translating his or her diplomas or whatever sort of official documents, he usually does it to participate in some sort of recruitment or some sort of official procedure, and then the household exemption cannot apply. If someone is really translating a document for a household activity, like translating a personal journal of a relative, for example, an ancestor, a long deceased ancestor, that can potentially still contain personal data that refer to people who are still alive or somehow can qualify as personal data still. I think the household exemption can apply, but what happens with the processing is one of the most interesting questions I have been confronted with in my practice with the GDPR. I think Melina would disagree with me, but I think then, since the controller is exempted from the GDPR by the household exemption, I think the GDPR does not apply to the processing whatsoever, and it does not apply to the processor either. So you can completely forget the GDPR in this sort of circumstances. Of course, in order to shield yourself from liability in case of an audit, it might be considered to have the client sign a written declaration saying that this content, this document will only be used for private and domestic activities. Yet another pitfall in dealing with individuals is that who don't know the law. So if an individual doesn't know the law and he's still the controller, and he gives you an instruction, so you are the processor as a translator, You receive an instruction from your client, the controller, to process the data in a way that is not compatible with the GDPR. For example, keep the data for longer than necessary, or I don't know, process, well, anyway, or handle the request from the data subject in a way that's not compatible with the GDPR. What if you receive instructions that are illegal, that are against the GDPR? It is the processor's duty, actually, in such cases, to inform the controller that this instruction is not compatible with the GDPR, and so it cannot be carried out, cannot be acted upon. All right, and that is quite problematic. It might be that the European Data Protection Board actually suggests that it should be stipulated in the contract what happens in such a case. So in case of a warning, if the controller insists that this processing should still be carried out, the processor should, for example, be given an opportunity to rescind the contract. But well, these are technicalities, but this is one of the pitfalls for processors in dealing with controllers who are private individuals. So a very important question.
Thank you very much, Pavel.
Thank you, and I hope that that has helped you.
Okay, so we have now exceeded the time allotted for this panel. It's been very, very fascinating, and there are a great many issues that we still need to discuss, but we do have another panel discussion this afternoon, which will cover a lot of the topics that we haven't been able to address this morning. There are also lots of other questions in the chat. Maybe if some of our experts have the time and energy, they could respond to questions in that way. Or if they write down, if they take a note of the questions, maybe they could respond at a future point in time to the person asking it. So we have a coffee break scheduled now. It was supposed to be 15 minutes, but if everyone wouldn't mind, could we come back in 10 minutes so we stick to our schedule? So we'll see you all again then at 10 minutes from now, so at 12:30 Central European time for our next topic, which is about how to mitigate risks. So a very practical orientated discussion from RISA. Thank you very much for all your attention. So welcome back everyone to the next session in today's conference about GDPR. I'm very happy to have Raisa McNabb talk to us now about how to mitigate risks in relation to GDPR and translation. And she's going to give us a very practical talk now about how we can do this, how we can reduce the risk mitigated. So over to you, Raisa.
Great, thank you, John. Can you still see my screen?
Yes.
Yes, okay, lovely. All right, so let's move on from the primarily legal domain to the practical domain now and talk about how we can, in practice, mitigate the risks to our businesses and to the data subject in terms of the processing that we do. So this is a very practical approach that we're taking here. And one of our breakout sessions this afternoon as well will be dedicated to this mitigating risks. So if there's anything further that you want to continue discussing or ask or whatever, then join us at the breakout groups. One of the things that many of us really struggle is essentially this idea that there are quite a lot of practical challenges within the sector for us. And those challenges arise from the fact that, especially when we talk about personal data in translated content, it is essentially quite often incidental personal data. So the processing activity, our primary processing activity is to translate content, translate a document into another language. And whether or not there is personal data often doesn't really play a huge role per se. Of course, if you're translating somebody's medical record, then the personal data in that medical record plays a really large role. But you might equally be translating other documentation that simply mentions a CEO or refers to somebody by name. So a lot of the personal data in the content for translation is incidental personal data. And the problems that arise from that is, of course, that we, especially we as processors, often have absolutely zero visibility on the origin of that data. And quite often our clients are in a similar position. That data comes from somewhere, but that data hasn't been specifically collected for the purposes of the translation. It's been collected at some point for some purposes, but that purpose may be quite far further up the food chain, so to speak. So there is little visibility over data origin. There is also quite often little visibility before we start as to whether there is personal data in the documentation that we translate or not. So certain types of documents are more visible. A medical record will presumably always have personal data, but other types of data, we're not going to necessarily know whether there's personal data until further down the lane. Of course, one of our challenges in practice is also that we pretty much always run a global activity. So we're doing transfers within the EU. We're transferring content for translation outside of the EU to adequate countries, for example, the UK so far and others as well. And we're transferring data to third countries. And essentially the controller should have the responsibility of ensuring that those transfers are okay, that those third countries that the data is being transferred to are safe and equivalent, but often that's not the case. Another challenge, practical challenge, is that our assignments quite often are ad hoc. So it's not like Amazon Cloud Services that manages masses of data from its clients. We translate individual documents that may be very similar from one day to the next or completely different from one day to the next in lots of different languages with lots of different sub-processors. And what we've also already talked about today is that data controllers, our clients, are often not aware of their obligations. So they may not be aware that there is personal data in the content for translation. they may not be aware that the translation process comes under GDPR, and they may not be aware that there needs to be a data processing agreement or standard contractual clauses signed between you, the processor, and the controller. So these are all very real challenges. And when we talk about these legal aspects of what we should be doing, we don't want to take away the practical aspects of what you see on the ground every single day of the week. So we recognize these, and we want to find a way to marry this conflict, essentially, of GDPR compliance and protecting the data subjects' rights and freedoms, and the practical work, the practical day-to-day work that we do, where these issues are real life barriers to us doing our business. But at the end of the day, the bottom line still is that it is our responsibility also to protect the data from the data subjects, so their person, and to comply with the GDPR. So we've already heard from Małgorzata, for example, that if the controller is not able to give you a data processing agreement, you need to take your responsibility as a processor seriously and ensure that one is put in place. So then we come to this question of lots of moving parts, lots of different types of risks around our processing activities. What can we do to, first of all, identify them? And then what can we do to mitigate those risks? So let's talk about assessing risk first. Essentially, the one thing to realize is that we've got lots of different types of LSPs. We've already said that within the context of this project, LSP we use for both freelancers and for language service companies, anybody who manages language services. GDPR doesn't tell you exactly what you need to do in every single instance, which is also what we heard from Mr. Wiwerowski this morning. And when you're thinking about the risks, the GDPR puts an onus on everybody to assess and identify risks, but that needs to be done from the point of view of your operations. It will be different for a larger company compared to an individual freelance provider. It will be different depending on what types of content you process, what kinds of operations you do. But there's some basic principles that we need to take into account. And if we do that, then that risk landscape, if you like, will become a lot clearer. So contractual compliance, we've already talked about a little bit, is absolutely critical. And that contractual compliance essentially means that there is a contract in place that says what you're allowed to do and how. And that same contractual compliance, which essentially should be put in place by the controller, needs to filter all the way through the supply chain, however many links there are. So whether you're a processor or a sub-processor, the same contractual obligation should apply to you. One of the challenges, one of the risk assessment elements that we within this industry need to go through is specifically to think about identifying and mitigating these risks, particularly for the translation activities. So we've said before that we've got certain business activities that we all carry out because we're all running businesses as well. There's lots of information around on there, but there are very specific elements that pertain to the translation and interpreting services that we need to identify, assess our risks to our own businesses, our own GDPR compliance through that lens. The third risk assessment principle that I want to highlight here is documentation. So carrying out a risk assessment is great, and you should be doing that. But what's better is that you carry it out and then you document what you're doing. So think about what you're doing, what kinds of processing activities you're carrying out and write it down so that it's clear to you and to your potential clients or the data protection authorities when they come knocking, what you're doing and why, and what have you done in order to identify the risk and take measures to mitigate that. So let's start with the mitigation part then. Contractual agreements. Yes, we need to have them. We need to have a contractual agreement between the controller and the processor. And we also need to have a contractual agreement between the processor and sub-processor. Now, today we've already talked about several of these types of contractual agreements. DPA, data protection agreement. DPA is a complex or a little bit confusing as a term because DPA is also used for data protection authority. But here DPA we use to mean data protection agreement. It is essentially the contractual agreement that outlines what is done with the data, how, so subject matter of the processing, nature and purposes of the processing, the duration of the processing, which takes us to data retention that we'll talk more about later today, types of personal data and categories, taking into account our specific processing activities. So a data protection agreement is a type of contractual agreement. And then we've got standard contractual clauses, or SCCs, that we've already mentioned also today. They are a type of agreement that you can use to put in place the relevant GDPR compliance requirements between the different roles or between the different actors in the supply chain. So the SCCs are a mechanism to contractually govern the processing activities. And there are also now EU SCCs for transfers to third countries. So outside of the EU and EEA and outside of countries that have been deemed adequate, like, for example, the UK. So you don't necessarily need to have an SCC. You don't necessarily need to have a free-form DPA, but you need to have a contractual agreement. The benefit of using SCCs that have been defined and modular templates have been created by the European Commission is that if you use them, fill them out and comply with them, then you're basically covered. The risk with having a free-form data protection agreement is that inadvertently you do something that is not GDPR compliant. You can access the SCCs online, of course, both the standard contractual clauses for the roles and for transfers to third countries that are set out in modular form so that you can pick out your role and figure out what you need to do. In EURLEX, in all of the EU languages, of course. What's good now is that today we are in a much better position in order to ensure that contractual agreements are correct and applicable throughout the supply chain. Because when we started this GDPR project, when the GDPR first came out, there were only standard contractual clauses between controller and controller, or controller and processor. But there were no clauses between processor and sub-processor. So this particular gap has now been filled, and we can now use SCCs throughout the chain, from controller to processor, from processor to sub-processor. So contractual agreements, absolutely, you need to have that in place. And if the controller doesn't put them in place, then you take steps to do that. My next point in mitigating risk is essentially understanding what you process. So reviewing, assessing the type of content and here we very much talk about the content in translation, understand what you're processing so that you understand the risk that is inherent in the type of work that you do. And here we've got very different approaches, because we've got some LSPs who process hardly any personal data. They've got commercial content or online web pages or whatever you have. And then we've got LSPs who specialize in legal translation, who day in, day out translate sensitive content with personal data, lots of it, and special categories of data. So in terms of mitigating risk, the GDPR doesn't tell you to do risk profiling on your content. But I feel that this is a really powerful way for you to understand what is the risk to the personal data, to the rights and freedoms of the data subjects with the work that you do, with the processing you do. And again, here, your client or the controller further up the chain may not understand, may not have the insight to do this work. So from my point of view, this is part of the transparency principle, but also the accountability principle, that we are the professionals, we know what we're doing. We need to be able to come to a position where we understand very clearly what we do and how we do it. So I would advocate content risk profiling. So understanding what you do and how. Is there personal data? If there's no personal data, there's no GDPR compliance risk. Is there personal data? Very little, completely non-sensitive, and so on. The risk is much lower. Is there sensitive personal data, special categories of data, people's health data, information about their ethnic origin, or so on? Consider also how you identify personal data, especially if the controller is not in a position to do that. How do you identify it? Who identifies it? How do you flag it up to everyone in the supply chain and to the controller? Is there a way for you to pre-process data so that the risk is lower, for example, by using anonymization tools that we'll hear from Manuel next? How and where do you retain data, and for how long? We'll also come back to that question. Whatever you do, involve everyone in the supply chain. So even if you're happy that your operations are okay and above the water, what happens further up or further down the supply chain? Are they also aware of these elements? Do they also comply with the clients, the controllers' requirements? Documentation, like I mentioned, is also a really strong way of mitigating risks. So understanding first what you need to do and then document what you do. So contractual agreements, of course, are documentation. Where are they? How can they be accessed? How do you document your assignments? How do you document the technical and organizational measures that you take to protect personal data at transit, for example, to third countries? And what kind of a risk assessment you've done for your operations, your processing, your documentation, your records, and so on. There are, within the language services supply chain, quite significant risks around using sub-processors and transferring content to third countries, probably more than for most other sectors, because we do a global activity, and for many translations, it is, we need to transfer it to third countries to translate into certain languages. So we need to understand the supply chain. We need to understand our parts in the supply chain. Where are we? Are we processor? Are we sub-processor? Who decides? Who do we need to follow? And we need to ensure this compliance throughout the processor chain. We need to know the risks around transfers to third countries and consider how we can mitigate them. Transfers to third countries are really tricky, because essentially we should be in a position to say data is being transferred to a third country outside of the EU, EEA, outside of adequate countries. Is it safe within that third country? And quite often it's very difficult for us to say that, because we're not a large multinational. We don't have an army of lawyers to assess the political situation in a third country anywhere, but we're asked to make that judgment. So consider whether you transfer data to third countries, what countries, how can you ensure that that data is safe? How can you take steps to mitigate that risk? Is the controller even aware that data is being transferred to third countries? They should. Technical and organizational measures were also mentioned earlier, and those are really key ways of mitigating the risk to your business, to the data that you process. And here, when we're looking at analyzing the risks around the measures that we're taking, we should of course take into account that those measures may be different depending on whether you're an individual freelancer or whether you're a company. So they're commensurate with your processing activities. But there are, again, lots of different touch points at which things can go wrong or the loop can break, because there's a lot of transfers within our type of processing activities. So we're transferring data from the controller to the processor. The processors have got their own data repositories. Where are they? How are they safeguarded? There are transfers from the processor to potentially lots of sub-processors. There are the sub-processors' data repositories. And then there is the whole transfer back to the controller. How is that done? How is the data being kept safe and secure throughout these by using technical and organizational measures? And here we're talking about data protection, encryption, for example, ways with which we can ensure that the data that we transfer, that we process, doesn't get intercepted and used for something else, which reduces the risk for data breach. Data retention is something that we'll come back to a little bit later on, but has already been highlighted as a key risk area for us. And here I would come back to this idea again to say, if there's no personal data, there's no GDPR compliance risk. Of course, there may be other risks around data protection. Can we use tools, technologies to mitigate that risk, to lower that risk? Anonymization, for example. Fundamentally, like we've heard already, the controller decides what is being done to the data. Where does the data go? We need to assume our responsibility with transparency of our supply chain, of our processes, so that the controller has got visibility over what's being done to the data. So the controller should decide, and the supply chain all throughout it and back again should follow that. So within the context of this TEW GDPR project, there are still a lot of gray areas, and we've talked about those, and we need to continue working together in order to figure out what we can do with our practical day-to-day life, stay compliant with the GDPR without drastically jeopardizing our entire sector or our entire business activities. I'm sure we still need to have title compliance. There are still certain things that we do, but there are also lots of practical approaches that we can take to reduce the risk, to mitigate the risks that we've identified. Once we've identified them, once we understand fully what we do with the data, and once we understand that it flows from the controller throughout the supply chain and back again. So that's my take on mitigating risks and how you can do that. The EU ATC GDPR and personal data and content for translation guide has got a little bit more around this and the questions that you can ask yourself, the types of activities that you can do in order to mitigate the risks around the type of processing that we do. It doesn't take away our obligation for GDPR compliance, but overall it plays into this accountability principle, transparency principle, data retention, all of these elements that flow to us from the GDPR requirements. We've got a couple of minutes. If anybody's got any pressing questions, we can take those before I give the floor over to Manuel to talk about another practical aspect, data anonymization, whether that can be a tool for us to mitigate risks for personal data in content for translation.
I don't see any questions at the moment relating to your presentation. So we have a question, should we be deleting all old emails?
Well, I would say to that's one of the gray areas that we have, that we talk about files, folders, translation memories, and we forget that emails are also data repositories. So all of our saved, and we like to save everything. I mean, John said that before. We're an industry, we like to save absolutely everything. And there's no difference to emails. Emails in your Outlook folder or Gmail or whatever you use, they are stored data. They are a data repository, so the same principle applies there. And I would also go back to something that Melina said earlier. If we only keep data for as long as we need to. So essentially, although even if you would like to keep all of those old emails, and they sometimes do come in handy, if you really don't need them, why should you keep them? And here we've got, of course, in emails, we've got two different types of data. We've got the data that is still being sent as attachments, translated content as attachments from the client to you, perhaps even the other way around. So data and content for translation, but there's also data pertaining to your business activities, so your clients' personal data, your suppliers' personal data. So there is no difference to that.
And we have some follow-up questions around emails, Raisa. What is old, and does email include unsolicited emails that you might receive?
Well, what is old is like the the British saying, how long is a piece of string? This is where we come to the data retention period, right? It needs to be appropriate to the processing activities. So we can't say it's 6 months, it's a year, it's 5 years, it's 10 years. It needs to be commensurate with your data retention policies. Unsolicited emails, why would you keep them anyway, is my answer to that. If the data is not there, there is no risk. So especially with unsolicited email from people whose personal data you've got no interest in keeping, why would you keep it? If you don't have a pressing reason to keep it, then if you delete it, you've got no problem. That's my practical take on that. But I am going to now share my screen with Manuel's presentation, and we give the floor over to Manuel.
Hi. Yes, can you hear me?
We can.
Yes, we can hear you.
Yes, okay. Good. I'm just using my new iPod. So trusting the technology here. Okay, so my role within the committee is to add the vision of a developer of anonymization solutions. Now, before I delve more into the matter, I have to stress that anonymization is impossible, cannot happen. We really need to talk about de-identification. If it is okay that we speak about anonymization and we'll understand what it is, but if you hear experts talking about the subject, they know that full anonymization is impossible to achieve, because there is always a risk within a text to have world knowledge that would lead a paragraph of text towards the identification of a person. So I'm going to use the term anonymization because we all do, and we all understand what needs to be de-identified. But essentially, anonymization for us means de-identification of personal data. And that is what software does. Software is trained, as we shall see in a minute, with neural networks, with rules, etc., so that named entities, names, surnames, bank details, telephone numbers, emails, URLs, and sometimes next of kin are deleted, are identified and then deleted. So next slide, please, Raisa. Okay, there are three approaches to anonymization. When we have an incoming text, typically this text contains personal data, and we can apply three techniques in order to de-identify the data that is contained therein. First one is anonymization with gaps, where we will use a line with placeholders, or we can use pseudonymization. It's pseudonymization, it's not pseudo-anonymization. It is a use of synonyms. Next slide, please, Raisa. With gaps, when we use anonymization with gaps, our software will detect a number of items or entities within the text. So in this case, we are detecting names, Sarah Palin, Donald Trump, etc. We are also detecting locations. Location can lead to the identification of the facts or the person. And we are also identifying dates, such as Monday, the 26th September, and so forth. So anonymization with gaps is straightforward. There is no information conveyed here. The data is deleted, and the same placeholder is placed in all cases. There is no identification as to whether we are de-identifying a name or a date or a location. The advantage of this approach is that it really doesn't, we don't have to, we can forget about gender issues, about quality volumes, about adding any type of tagging or further information into the process. Next slide, please. Okay. Placeholders is also very popular. It's a very popular approach, very similar to the previous one, where we again we use a placeholder that we want to use. This can be a $sign, it can be an X, it can be a euro sign, it can be a ZZ, etc. The disadvantage of these two methods, placeholders and gaps, is that they render the data quite unusable. You can't really do much with the data if you plan to either monetize it or share it in any way. However, these are two very good methods for people to de-identify the data that is there. I'm using the same example here and before, but you can imagine that for applications in a medical environment where we're dealing with patient data, it suffices and really more than suffices. Next slide, please. Right.
I think that's it. Pseudonymization.
Pseudonymization.
Yep.
Yeah, next slide, please.
I think that. Can you not see it?
No, my.
Okay, let me just go back. Mine change.
Okay, yes, okay.
Yeah, is that all right?
Yeah,
Yeah.
yes.
Thanks,
Yeah.
Manuel.
So the most exciting technique in the identification / anonymization is pseudonymization. Now, this is very interesting because we use, and more challenging as a developer, because we use alternatives to the entities that are detected. So in this case, Sarah becomes John, Track becomes Jane, Donald Trump becomes somebody else, and different places are used. The beauty of this method is that it aids reading. So especially because the same names are used all the time. So if Sarah Palin here is entity number 1, and we decide to use John Doe, we will use John Doe all the time, every time that Sarah Palin was mentioned. So this is very good for material that comes out of legal courts. It aids reading and understanding of the data. There are challenges, however. There are challenges in some languages when you have to match gender. It is not happening in this case because a female is substituted by a name, by a male name. It doesn't affect English so much, but it's critical in other languages where you can't simply use a male name for a female. Yes, it is more challenging for a developer. Even so, more because we have declensions and cases to take into account, and that is even more challenging if you wish than machine translation. You need to detect a case. Morphologically rich languages are the ones that score worse in this type of the identification. However, we apply the technique in order to get personal data out, to lose all kind of traceability. So it's a very widely used technique, especially in the legal field. Okay, next one, please. Okay, so as translation professionals go, one question can be, okay, this is very good, but how it work? Okay, there are a number of systems out there in the field that you can search for commercial systems. Pangianic led a European project designed to develop a multilingual anonymized de-identification tool in all the official languages of the European Union. And that software is freely available. The code is in GitLab. You can go to the project's website and download it. However, I have to say that is a software designed, I have to stress this, it's designed for public administrations. It's not designed for a simple Windows user or Mac user at home. if you have sufficient computer knowledge, you can probably put it to work. But it's designed really for organizations, corporations, and entities. Commercial solutions, there are a few around. We have one, but I'm not here to promote ours. And they can interface with popular translation tools such as Trados or MemoQs or MemSource, etc. There is always an issue here about where should the anonymization software be located. It kind of, and I understand this well, it kind of defeats the object if we are sending data through the internet to a machine that is located in Italy, in Spain, in Germany, for it to anonymize or delete personal data and then sending the data back. I see that point. However, communications nowadays are very well secured, internet communications, point to point. And what you are sending most of the time is a segment after a segment. You're never sending a full document. Communication happens as snippets of text. So even if there was an interception in between the communication between the user and the GAT2 provider or the company, the most that that hacker could get would be a series of strings, and likely strings that are already anonymized, not full documents. Okay, next slide, please, Rice. Good. So let's have a little bit of fun. MAPA is the projects that I mentioned, multilingual anonymization, and I think we can visit the website. Everybody should be near a computer or a phone here, so that please go to the next slide, Raisa. And I would encourage you to have a play with it. Very shortly, I'll mention what the aims were. Develop the toolkit so it can be applied by public administrations. This is in use already at the Spanish Ministry of Justice. It's in use by the European Ombudsman, the people that are at a national level and a European level receive user complaints like, well, my telephone provider has charged me, this electricity bill is outrageous, there's a mistake in my whatever. It addresses all 24 European languages, from English even to Maltese and Irish. It's based on, has been developed on neural networks. I have to say that it also has a specialism in the use cases that were part of the project. So yes, there are different levels of accuracy in some languages, but it works very well as a black box where you can have two outputs, one multilingual and one proper to your language. So next slide, and I think we'll go to the, okay, we'll go to the way that we annotated data. There was a massive effort in annotation. We gathered data containing personal name, addresses, a number of entities in many languages, such as Bulgarian. A large chunk, a large section of the project was devoted to manually annotating data, so identifying names, persons, dates, etc. I think this is Bulgarian, and there is a Croatian example in the next page, please. Yeah. Romanian, yeah. And this was done month after month after month, and training after retraining of each little network until, next slide, please, until we got here. So I'd like everybody to, if possible, to go to the project website, mapa/project.eu. You'll see a demo page there. I'm not sure if I can share my screen. Grace, can I?
Yes, you should be able to. I've stopped sharing now.
Okay. Good. So let's go to Mappa. And I encourage you to use it online just to try it and see how anonymization works in real life. So here at the top, we have the number of entities that we have worked in identifying in texts coming from 24 languages. I'm going to write something here. Now I work, and this is my nations visiting. Okay, so I have a several options here. I can either detect or obfuscate the entities. If I detect, I only run detection, and you can see the guts of the beast, if you wish, and how it works. If I choose to obfuscate, I will simply delete the personal details to comply with GDPR. If I choose to detect, there will be no deletion. There will be simply an identification. Now, this is running on a multilingual engine. And there are other engines that have been developed for use cases. So, I know this is English. So let's try English and run it again. This has worked better, but it hasn't beat United Nations. So here are this is Mappa. There is no one technique for everything. Usually when the Ministry of Justice or the Ombudsman are working, they choose a number of engines. So one benefits from the other. I'm going to use text coming from a different sides. If it contains personal data. Okay. So here you can see how the neural network is detecting entities. Or then again, we can choose just to obfuscate and simply delete them. So that Mappa offers a high level of accuracy. However, it is a basic system. Anybody willing to deploy Mappa will require a certain knowledge of computing and adaptation to the circumstances. And really, in a nutshell, Raisa, this is it. Has everybody got the web address to play with Mappa?
I've shared it through the chat now.
Okay.
And I'm sure we'll have questions, but I'm going to use my prerogative because I can unmute myself and ask the first question as Manuel. So in terms of using different types of anonymization tools, is it right to say that there's quite a lot of challenges in trying to use those tools pre-translation because of the different complexities around language, that you can't actually produce an accurate translation if you take out personal data with certain types of documents? So would you see the anonymization tools more useful in terms of treating translation memory content, for example, so clearing TM content, perhaps even our old legacy TM content from personal data and making it safer that way.
Yeah, I understand. No, it can run both ways. It can run MAPA at least, and most anonymization tools or the identification tools, they now run both in offline mode and online mode. As MAPA, as you've seen, is very fast. It works on CPU. It's traditional computer. You don't need GPUs like you do for machine translation. So you can run it live, absolutely. You can run it live even for an organization, or you can also use it to cleanse all data, as you said, on offline, pumping TMX material or documents.
Yeah. But if you do it on content for translation before it's being translated, then that may hamper, obviously the output of the translation, because if you don't translate Germany, then that's an issue, or you can't even reproduce that.
That's true. Yeah, the question here always is how much knowledge does the translator need to have? And obviously, if you don't translate generally, because all you see is some asterisks, that word will be substituted, and Germany will be replaced as such with serialization, and it won't be Allemagne or Alemania, anything like that. However, the uses that I see, or at least our clients that are using our anonymization solutions, use it to share data. So they apply it after translation, not to keep the translator out of the loop. They trust the translator. Okay, and sometimes, there is translation, and Germany is missing, the country name is missing, the street is missing, so it's missing. We don't know it. We translate around.
Yeah. I'll take there's a couple of questions coming through, but I'll ask one MAPA related question before we take those. MAPA we've seen online, and you've said that, if you want to apply it, if you want to take it into your daily use and use it as a tool, you do require technical expertise to do that. Do you see commercial off-the-shelf products coming through that deploy MAPA technology, so that we could buy a tool that does what MAPA does to clean up legacy data?
Yeah. We have one, but I'm not here to promote our technology. I know of other company in Spain as well, in the north of Spain, and there are other companies. Well, MAPA is based on text. It doesn't handle images. We have to clear that. But I do know of other technologies that only focus on image, for example, on face recognition or car number plates, and they're very successful, and they sell that to people that run car parks, because the car park needs to take a picture of your car, meaning for insurance purposes, and that has to be deleted or anonymized, etc. Or the person getting in or out of the car was the number plate, so you automatically the barrier leaves when you leave. So there are a number of applications. The last frontier where we doing research is multimodal anonymization. So that's taking into account speech, image, and text. In other words, video as well.
Yeah. Wow.
That is in the pipeline.
Yeah. Okay. So let's take our questions. So starting with Ruth. How well does it currently work with mixed quality data? So social media postings with shorthand or spelling issues?
Spelling doesn't matter. Spelling doesn't matter. The neural network is not trying to understand what it's saying. In fact, you could put garbage. You could mix languages using a multilingual model. One sentence in Portuguese, the next sentence in Italian or Romanian, and MAPA would detect the language and apply it. It detects entities based on how sure it is that something is a place, a telephone number, or a person.
Yeah. Okay. Claudia is asking, at which stage of the process are translations of obfuscated months or weekdays inserted? How do you deal with date formats or name suffixes to be localized? Is the short answer you don't, because MAPA identifies them and then it takes them out, so you can't restore them. Yep.
That's right. That's right. Yeah, MAPA doesn't pseudonymize. Obfuscate is a one way. MAPA is multilingual anonymization for public administrations. It's not multilingual pseudonymization.
Yeah, and it can't be. So if we talk about anonymization, it cannot be reversed. So that is permanent. Right. Once the data's gone, the data's gone.
That's right. Yeah. Pseudonym. If you use pseudonyms, then that is reversible. That is not anonymization. It's pseudonymization.
Yeah. Carola's asking.
Which helps you comply with the law. The law for what GDPR says is that anonymization has to be irreversible for it to happen. If it's reversible, then it's not anonymized. It's something else. You're dealing with your data for very good reasons, because you need to go back to the data, but it's not. Then it's pseudo.
Yeah, Carola's saying. Why would a country name be protected by the GDPR if no connection to a name is possible? It wouldn't unless
because the speaker in today's conference lives in Spain, and therefore you can guess only by the country where I reside who I am. It's a place.
This is one of the gray areas that we've talked about in within our working group. What is personal data? What data do you need to make it personal data? And this is a challenge for us. It doesn't necessarily need to be your personal details, your address, your health data, whatever. If you can be identified from it, then it's personal data. Yeah.
Exactly. Let's take another example that I've used a lot. The son of the mayor of London. There are no names there, but I've just revealed who I'm talking about.
Yeah.
So one of the things that MAPA does, I can remember, MAPA does as well, I was for sure, is to also detect jobs.
Okay. Yeah.
Okay. If there is a translator in the room and everybody here is military, well, I know who I'm talking is the translator. So I only need to find out who's it.
Yeah.
So professions need to be deleted. Next of kin needs to be deleted as well.
Interesting. Gabriela is saying or asking, what do you think of Trados TM anonymizer?
I haven't tried it. I've heard good things about it, but I've never used it. I've heard that it works well.
Okay. So anonymization is a method that we can use to mitigate risk. You've said it yourself. We'll come back to it later on with our legal experts to talk a little bit more about, is that enough or not? You've said it can never be 100%. Very few measures can, and this is what we talked about at our working group meetings as well, that no IT company is ever going to promise you 100% data security. This kind of falls into that category as well, but it is clearly a really, these kinds of technologies are really great ways of mitigating, of reducing that risk used correctly.
Yeah, absolutely. Even an off-the-shelf system that hasn't been customized will probably run at accuracy level. We call it F1 recall level in excess of 92, 95, 96%. Is it perfect? No. Can you miss Raisa's name, Manuel? Yes. But that will be the one time in that will be the one time in 100. That it's a great help, but you know, I'm sorry to say that computers crash sometimes. You know, an email fails too. But however, it's one onion skin that, you know, it's another layer of protection that we.
Fabulous. Thank you, Manuel. Shall we go to lunch, John?
Yes. Thank you, Manuel, for your presentation. Yes. So we, according to the program, we'll be back in half an hour from now for our next panel discussion with the legal experts and the really hot topics of can we keep our translation data, translation memories, retention periods, and other pain points, these gray areas that we've been talking about, to discuss all of those with the legal experts on our expert group. So everyone, enjoy your lunch, and I'll see you again in half an hour.
All right, thank you.
So, good afternoon. Welcome back, everyone. Do we have all our panelists here?
I'm here.
Yes, I am also here. I have some problem with camera. I don't know what to do because it don't want to connect.
Okay, but we can hear you. So,
Okay, so what can I do? Because it's somehow inactive out of the blue, because it was working earlier.
yeah, it was fine before, but okay, it's not working now. Well, we can proceed even without the camera. I think it's
okay.
It's not a major
Because I'm
issue.
afraid to leave and join again because I don't know if it will work.
And is Pavel back yet, or yes? Okay, so welcome back, everyone, for this second panel discussion of the day. Raisa is going to be leading this panel and going to be looking at the very hot topic of how we can keep our translation data, translation memories, and other pain points, so unclear issues in the GDPR and how these affect the translation and interpreting sector. So over to you, Raisa.
Thank you, John. And hi again, everyone. Hope you had a good break. Before we start with the session, we wanted to share with you greetings from Kyiv. Lock lunch is going on at this very moment. Our colleagues in Kyiv are still continuing to work despite everything. And they have put together a lock lunch event remotely, of course. And we wanted to show our support. So although we can't join them today, and we're too many to do that, we wanted to just acknowledge and send our best wishes, our regards, our support to them having lock lunch online in Kyiv at the moment, and also to share a recent multilingual magazine interview with the lady who has organized Lock Lunch today, Maria Malekina, who is a manager at a Ukrainian LSP Technolex translation studio, talking about her experiences in continuing to work and life in Ukraine. So we just wanted to pause here and send our support, send our thoughts over to our colleagues there. And of course, we'll support them in any whichever way we can. But our program today moves on. And like John said, we are now going to move over to the big question of data retention. Can I keep my translation data, translation memories, and those tricky questions that we've already mentioned? But I'm just going to swap over to my specialist presentation. There we go. So the question is, can we keep our translation data? What are the pain points? What are the challenges that lie ahead? And we wanted to do this session partly from the point of view of the practitioners, of us trying to find the right way of applying, implementing, complying with the GDPR, and then the legal aspect. So our panelists are all here, but we'll ask Małgorzata and Paweł and Melina to take the floor again as the legal experts and open up some of the legal complexities around data retention. So I wanted to ask Małgorzata, whose camera is not working at the moment, but she's there, to start with us.
It's okay now.
Okay, great. On the key principles of the GDPR.
Yes, so first of all, we need to stress that the key point in our discussion should be this regulation of Article 28 3.g, that our agreement, because when it comes to the data that we are processing on behalf of our client, yes, because these are data contained in this translated content. So the agreement should stipulate that at the choice of the controller, we have to delete or return all the personal data to the controller after the end of the provision of services. So it means that when we fulfill our obligations from the agreement, of providing services, translation services, it means that we have to wait for the decision of controller, and controller determines if we should delete this data or return. There are no further options. So there's no option that we can keep it on behalf of the controller, because it means that we have another agreement for another purpose of processing on behalf of controller. So I've heard that there are some situations in which contracts between controller and processor encompass such a provision that processor can keep the data, personal data, for purpose of archiving, for example, for 6 years, 3 years. So in my mind, and as I understand the obligations arising out of GDPR, it is very dubious, and it is circumvention of GDPR regulations, because it means that in such a case, we process the data, because storage is also processing, and it is obvious in the light of the definition of data processing. So it means that we process the data on our own purposes, because archiving means that we archive it and can take it whenever we want, yes, because it's our obligation. And it means that we are here as a controller. So even if we have in our agreement such a provision, it doesn't allow us to avoid regulations which concern to controller, because in fact we are controllers. So the question is, if we finished our translating service, if yes, it means that we keep the data just until the decision of controller. Then we or delete or return the data. I mean, if we anonymize the data and keep only the rest of the text translated, it's okay. We are here pointing only the personal data. So GDPR is irrelevant when it comes to other content. And if we want to archive this translation with the data for our own purposes, it means that we are controllers. So we have to fulfill all the regulations which are destined for the controllers. So we have to do all the things that are stipulated in the GDPR as to controllers, and we have to facilitate the possibility of exercising the rights through by the data subjects. And sometimes we even don't know the data subjects, yes, because if translated content contain the personal data of third parts, which we don't have any relation with, it would be very difficult or even impossible to fulfill the obligations from GDPR. So the only reason, the only way to to avoid the responsibilities and liability from the GDPR is to anonymize our translation memoirs. So that is the main conclusion which we can draw on in the light of GDPR. But I've heard some trials to distinguish between passive storage and active storage. Yes, and I have to stress that it is very interesting concept, but there is no very vivid and clear legal base for this in the GDPR. So maybe it will evolve the interpretation of GDPR provisions and regulations in that way, and it could be interesting and very helpful for your profession. But now I don't see very good ground for it in GDPR.
Okay, thank you, Małgorzata. And we'll come back to this this question. And of course, everything that we've talked about today derives from the basic principles of the GDPR, and we've talked about it before: transparency, accountability. But there are also others that we've mentioned briefly today, and they have got very much to do with data retention. So purpose limitation: you only store the data for a defined period and for an agreed purpose, and that purpose is agreed with the controller. And there's the principle of storage limitation, so you only store it for the agreed time. And then there's the principle of data minimization, so you only store the necessary data. And of course, we know that our legal experts are very clear on this, but we know that the current approach of our sector clashes with all of this, because what we do at the moment is that we do store and we do archive all possible documents and data, often for an indefinite period of time, because we think that they might be useful in the future, or because they're genuinely useful. And we store translations in translation memories indefinitely, and we reuse them at will, because TMs are our core business assets. And this is a real problem for our sector, and this is the problem that we haven't properly addressed, but that we're addressing now and discussing now as part of this project. We have heard already from our legal experts, from the data protection supervisor, that the GDPR doesn't make exceptions for our sector. We're not special. I mean, we are special, of course, but we're not special from the point of view of GDPR compliance. And I think it's becoming very clear to us now that keeping data indefinitely, just in case or for some purpose, is not okay, and the GDPR does not allow that. So then that leads us to questions of how long are we allowed to keep data? Who should define data retention periods is a question that we've already had here. Another question that we've had today is what about liability, or the requirement to retain certain data for legal purposes, or for future updates, or for client complaints or payment issues, or in Poland, where there is a legal requirement for certified translations to keep translations for a certain period of time. We've got a couple of comments. I think Paweł has commented. Is that, Paweł, a response to a question, or do you want to come in and comment at this point before we move on to talking about data retention specifically?
No, it's an answer to a question.
Okay. Great. So maybe we can take that. You can take that later then in your section. But I want to invite Melina to join us now to talk about data retention and hopefully give us some answers as to how long can we keep data and what can we keep data for.
Thank you, Raisa. I already mentioned that earlier when I was talking about our main obligations under the GDPR when we are controllers. In the case where we are controllers, we must do what the GDPR says, and that is comply with the purpose with the storage limitation principle. That principle that obliges us to delete or destroy any data from the moment that this data is no longer necessary for the purpose for which it was initially collected. There might be some national legislation on specific data sets that we may process, in which legislation could provide that we must, as a legal obligation, keep some kind of data for a specific period of time. I earlier talked about an example we have in Greece for tax data that we are obliged to retain for 10 years. Where no such legislation exists, then we should follow the storage limitation principle and keep the data only for as long as it is necessary for the purposes for which it was collected in the first place. But all of these concerns only the processing we undergo as data controllers, and this is when we are talking about administrative client data or supplier data or employee data, perhaps. We usually advise that we could keep some more data for a longer period of time when we want to have the data for the purpose of exercising relevant legal claims. For as long as the law provides for us the right to exercise some legal claims, or that the law provides that someone else might exercise such a claim against us, we could retain some of the data so that we would be able to address those claims. But in that case, we should always keep in mind that we should keep only the data that are relevant and necessary for those claims. That means that we might we may not keep for example, the translated text itself, but we could have, for example, our client sign us a receipt of the text, of the translated text, or that he obtained and received the text, and that it is fine from him. So such a receipt would certainly be useful in the case that this client at a later stage decides to exercise a legal claim against us. In the case where there is no other way to exercise or to support such a claim, such a legal claim, and we absolutely need to keep the translated text, then we should still try to minimize the data in it and delete any data or anonymize any data that is in the text and that is not relevant to the purpose of this specific processing, which will be defending our legal claims. When we are processors, we are not to decide on the data retention periods. As Manuel Herrands said, this is the controller. It is the controller who has to decide on that, and we, as a processor that are processing on behalf of the controller, have to obey, have to comply with the controller's documented guidance. So, as far as data in translation memories, I don't think if you want me to refer to that now or later on.
No, we'll come back to that later. But are you now saying, Milena, that if we talk about personal data and content for translation, of course, we agree that, you know, retention periods, how long that data is kept, are defined by the controller. But if we have a conflict between a data retention period set by the controller and a legal obligation to, for example, by a certified translator to retain translations for a certain period of time, i.e. union law versus member state law, which takes precedence?
It's absolutely certain that the legal obligation prevails any contract or any agreement or any request from the controller.
Yeah, so that's our answer to the especially certified translators out there, that if there is a legal obligation to retain the data, then that overrides the contractual agreement with the data controller. But I suppose, of course, good business practice would mean that the data controller is informed of the fact, so that they're even aware that this, that the data is retained for longer than in any contractual agreement.
I think that Article 28 provides for that and says that when the processor is not able to comply with a certain obligation of the contract agreement, of the data processing agreement, he should notify the controller about this legal obligation that makes him does not leave him any choice but not to comply with a certain clause of the agreement. So
Great.
Yes, we should notify the controller on that.
Yeah, right. Thank you, Milena. So we've talked about data retention period, and we've said before that there is not one period. There's not 6 months, 1 year, 3 years, 5 years, 10 years. It is defined by the data controller and or by member state law or other legal obligations. But it is the controller who owns the data, so to speak. So if the controller requires for the data to be deleted or returned, we must do that all throughout the supply chain again, unless there is a specific legal reason that we cannot do that. One of the other key areas that we talked about within our working group is defining data retention period based on the period for the provision of services, of translation services, because there are often client queries, or there might be complaints or updates or whatever. So one of the areas that we're also looking at is, should we define what is a period of provision of services? Does it end when the translation is returned to the client? Is that the end of the data retention period potentially, or does that go into once the client has accepted the translation, once they have perhaps paid for the translation and so on? There are no clear answers to that, so we're not going to tell you today what those answers are. But these are some of the gray areas still existing in terms of talking about provision of services. When does that end for the kinds of assignments that we do? Okay, let's then move on to talking about translation memories, TMs. We've said that the GDPR won't make exceptions for our sector, but we know that translation memories are absolutely some of our most critical assets. And also we know that we have huge legacy TMs, so huge repositories of legacy data from before GDPR, full of, actually, we don't know what they are full of, because often there's years of accumulated data in there. So I'm going to ask Małgorzata to come back now and talk a little bit about the big problem with our TMs, and for us to get a clear answer on, can we retain data in translation memories?
Sorry, you're muted, Małgorzata. You're muted.
Sorry, forgot. So as I previously said, and I will stick to it, after the end of the provision of services, it is our own risk. So we keep the data on our own risk, because we are the controllers. Any purpose exceeding the primary purpose, which were defined by the controller, is a new purpose for processing, and it means that we have to have legal ground for that. it. So if you have any legal ground, this legal ground can be regulation of union or member state, as we already previously stated. But if you have no such regulations, it means that you have to go back to Article 6, find a legal basis for keeping the data, and then you turn into controller. So it means that you bear all consequences for facilitating exercising of the rights of data subjects. And this is the main problem, because if you don't know them and you don't know any, you have no connection with them, how you can facilitate it and how can you fulfill obligations as a controller? In that case, it means that you keep the data on your own risk. In fact, it is the risk is not very grave, yes, because if you keep it like a so-called passive processing, yes, passive storage, probably it won't leak, it won't be the subject of any inquiry from the state institutions, but the risk exists, yes. So you have to bear in mind that as a controller, you didn't do all the obligation which are imposed on you by GDPR. So if you bear it in mind and you agree to bear that risk because your advantages are greater, so okay, but you have to be conscious that you are the controller in that case. You are not longer do it on behalf of the processor.
Great, thank you, Małgorzata. So this is the crux now of this gray area that we're coming to, that essentially what we have found out through the scope of this project is that when we transfer data onto translation memories, we're starting to process data, use data for our own purposes, not the controller's purposes. So we're talking about this, this question of when do we turn from processors into controllers? Do we? And what happens when we do? And for opening up some of the further considerations and also some of the guidance that is starting to come out from national data protection authorities, Pavel will join us now to talk us through those.
Yes, thank you, Raisa. What I'm about to say is perhaps not very new. It has already been said numerous times in this very workshop, but I guess some things there is just never enough of repetition concerning some such things. So just to make sure that we are all on the same page with the controller processor distinction, let me simply tell you once again that the controller is the one who determines purposes and at least the essential means of processing, is the controller who is responsible for GDPR compliance and who should be able to demonstrate GDPR compliance according to the principle of accountability. And the processor is the controller subcontractor. In a way, it's a person or entity who processes data on behalf and on instructions from the controller. However, if there is a change of purpose, there is a new processing, and there can be a new controller. So the attribution of data processing roles and responsibilities starts again with a new processing, and new purpose means there is a new processing operation. Can we move on to the next slide, please? So the client as we said, we imagine that the client is the controller for the processing of any documents that he provides for the purpose of obtaining the translation. However, the LSP, the translator, the translation company, can become controller when it reuses the data for a different purpose, like feeding translation memories. Okay, can we move on to the next slide? So, if you are a translator and your client, the controller, entrusts you with some documents that are to be translated with some personal data, your role is to process the document on behalf and under the instructions of the controller. However, if you decide unilaterally to reuse the data for a different purpose, like, for example, including some pieces of this document in the translation memory, you actually infringe the GDPR, and you are to be considered as a controller for the new processing. So unauthorized reuse of data by a processor for a new purpose, for the processor's own purpose, normally exposes the processor to penalties, contractual liability, for example, vis-a-vis the controller for not respecting his instructions. And in addition to this, the processor becomes now the controller for the processing, so he becomes liable, responsible for GDPR compliance for this new processing, and so can be exposed to sanctions for not respecting the GDPR. Can we move on to the next slide? Now, the key question here is it possible for a processor to lawfully reuse the data for his or her own purpose, the data provided by the controller? The French Data Protection Authority, the CNIL, has issued very interesting guidance on this very subject recently in January. And let me be clear, this guidance formally only applies in France, although the CNIL is a very influential data protection authority. It's historically the first data protection authority, the oldest one, created in 1978. And it is not impossible that this guidance will also influence other national data protection authorities from different countries. So it is worth listening to what the CNIL has to say on this question for anyone. So according to the CNIL, the controller, that is the client, can authorize the processor to reuse the data for its own purposes under a set of conditions. First of all, the reuse of the data has to be for a compatible purpose. So the purpose of reuse, the purpose for which the data are reused by the processor, has to be compatible with the initial purpose. And this assessment of compatibility is the responsibility of the client. So it's up to the client to decide, because he is the controller, he can authorize reuse, or he can issue an instruction that authorizes reuse, so it is his responsibility. So in assessing whether the new purpose, so for example, feeding the data to a translation memory, is compatible with the initial purpose, that is translating a document, the client should take such elements into account as, for example, the nature of the data. So if the document contains particularly sensitive data, like health data, for example, then this test will probably be against compatibility. That is, the client should probably not authorize the reuse. However, if the data are not of particularly sensitive nature, this may weigh in favor of reuse. And another element that should be taken into account by the client in deciding whether he authorizes the reuse or not are the safeguards applied by the processor, such as the security measures that the processor puts in place, or the anonymization of the data, pseudonymization of the data. These are all safeguards for the interests of the data subjects that should be taken into account in deciding whether the reuse of data, for example, in translation memories, should be authorized by the client or not. The authorization should be specific. So for a specific purpose and not general. You can reuse the data for whatever purpose you want. It has to be specifically limited to a well-defined, clearly defined purpose. The authorization should be given in writing, because the contract, it's as if it was part of the data processing agreement that should be in writing. This authorization should also be in writing. And the data subjects, that is the individuals that are concerned by the data in the document, should be informed about the new processing. And this is again the client's responsibility. This is the controller's responsibility to inform the data subjects that he or she has authorized the reuse of the data for this particular purpose by a processor. This is the client's responsibility, but the task itself of actually informing the concerned individuals can be delegated to the LSP. Still, for this new processing, so this part only shields the processor, the LSP, from liability for GDPR infringement. But still, for this new processing, the LSP becomes controller and so becomes responsible for GDPR compliance, which means that he has to define a legal basis, define the data retention periods, define the security measures that we put in place, etc. And so this is it from me and from the French Data Protection Authority concerning the reuse of the data by the LSP or by any processor for that matter. Thank you.
Thank you, Pavel. Yes, so basically you can, but there is a major problem here for our industry, and that is primarily informing the data subjects, whom we don't often know, have no access to, no conceivable way of informing about anything. And of course, we often know that probably our clients haven't informed them either of the processing that their data is about to undergo in translation. So there are several layers of complexities around there. So we've got a few really interesting questions there. So we'll take those in just a moment, but we'll quickly talk through the ways of mitigating these risks that we've already looked at. Anonymization, pseudonymization, we have found are really powerful ways of removing or changing personal data in content. But we've said that that also counts as processing, is seldom, if ever, 100% accurate. We need to do those kinds of activities before the agreed data retention period is open. We need to figure out what is the appropriate agreement. So what is the definition of the scope of services with your client? What is the definition of the end of services? Do we have an authorization? Can we get an authorization to use personal data for the purposes of the LSP? What are those purposes? Okay. We wanted to say a few more words about sub-processors, although we've talked about them a little bit, so maybe we will Pavel, go through this quite quickly so that we can take our questions as well. What do we need to take into account with sub-processors in terms of data retention?
Yes, well, I'll be as quick as I can. So the processor can hire a sub-processor only if it is authorized by the controller. The authorization can be general or specific, but at the end of the day, it doesn't really, it's not a huge difference, because still, in a way, the controller has to agree to every particular sub-processor individually, cannot agree to a group of sub-processor, a category of sub-processors, if you will. So when, as a processor, you hire a sub-processor, so for example, as an LSP, you hire a freelance translator to perform the translation task. You are supposed to enter into a contract with the sub-processor, and this contract should reflect the clauses of the data processing agreement. So, the agreement between the controller and the processor, so that the sub-processor is de facto covered by the same sorts of obligations that concern the processor. It's really a prolongation, if you will, an extension of the processor from the legal point of view. Can we move on to the next slide? Thank you. So if there are sub-processors in the chain, the controller remains in charge of the processing. He still defines the purposes, the retention periods, and his instructions still have to be respected and followed. And the processor remains fully liable vis-a-vis the controller for the performance of its tasks. So the controller is as if it is as if the processor was still liable for the work of his subcontractors, of his sub-processors. So from the point of view of the controller, the processor, so from the point of view of the client, the LSP remains the contact point for any GDPR related issues. So adding a sub-processor to the chain doesn't really change that much when it comes to responsibilities. It's still the controller who's responsible. It adds, arguably, it adds some responsibility to the processor, because he is now responsible not only for his own work, but also for the work of the sub-processor. Can a sub-processor reuse the data for its own purpose? Well, the answer is no, unless perhaps the same set of requirements as in the case of the processor is fulfilled. If the sub-processor receives an authorization from the controller to do so in the same conditions as listed by the CNIL, and then of course the sub-processor would become the controller for the processing. But since the sub-processor is removed a step further from the controller, I think the possibility for him receiving an authorization is even more theoretical and scholarly, so to say, than in the case of the controller himself. So I think that the hypothesis of a sub-processor lawfully reusing data for its own purpose is a rather theoretical one. Thank you very much.
Thank you, Pavel.
This question.
Let's take a couple of questions then before we wrap up. There is a question on audits, so of transparency throughout the supply chain. It is becoming a common practice for agencies to state in their terms and conditions things like the company reserves the right to conduct audits of freelancers, facilities, PCs, etc. I suppose that according to GDPR, we can refuse any relevant audits, although we have signed such agreements. Silence from our experts. Can you refuse audits? I don't think you can if it's on GDPR compliance, because there has to be a trail.
I could just read you out Article 28, paragraph 3, point 8. The processor is obliged to make available to the controller all information necessary to demonstrate compliance with the obligations laid down in this article and allow for and contribute to audits, including inspections conducted by the controller or another auditor mandated by the controller. So the answer is clearly no. We cannot refuse any relevant audits.
Great, thank you. Okay, further, I think maybe one question. Sorry, John, we're eating into your time. Let me just have a quick
That's okay.
look.
I'm probably okay with less than 10 minutes anyhow to wrap up. So take another 5 minutes or so for questions.
Francesca is asking, I understand that if I store in my TEM, say the source and target text of the contract I've translated, by eliminating from such texts any personal data, would the reuse of the remaining text still be considered a violation without the controller's consent? So if personal data has been removed, can I put it in my TEM?
Take that, Lisa. I think that the answer is very clear here. Yes, as long as the text does not contain any personal data, and that is any information that has any link to an identified or identifiable natural person, then there is no processing of personal data, and yes, we can hold on and retain those texts. But that is not the case where even a slight piece of information remains that could turn the data subject into the natural person into an identifiable. If we can identify the natural person from some information that remains to the text, then we cannot speak about anonymization, and we cannot exclude this processing from the GDPR, and we cannot exclude the turning of the processor into a controller. So the answer is, if we are not fully anonymized irreversibly the text, and that means not only names and dates and etc., but any information that could lead to an identification, then we still have the same problems we were referring to earlier.
Right. And there's a question on liability, also from Francesca. Can a freelance translator acting as sub-processor, working for a translation agency, the processor, be charged with violation of GDPR if such translator was provided with pre-translated text for post-editing, by such agency in violation of the GDPR. I mean, if the translation agency did not obtain consent for the reuse of the text by the original customer or controller.
If I understand the question correctly, and it's quite complex, to be honest, I think obtaining the consent, if you will, or defining the proper legal basis to be more broad is the responsibility of the controller. And I think in this scenario, the agency is the controller, because it's the agency who decides that the document will be reused for translation purposes. But once again, I'm not 100% sure I understood.
Yeah, it's a very specific, I think it's a very specific scenario where machine translation output is used without the client's consent. So I think this question is actually about, can you feed your machine translation engines with data, which is then later on reused to produce machine translation output? And that's the same question as with translation memories. That's repurposing for machine translation, for the training of machine translation engines. And that's the same answer then for translation memories, that it is a new purpose by a new you become a controller for that data.
The LSP becomes the controller.
Yeah. Sorry, yeah. Yeah, that's right. Yeah.
The processors can be directly liable for some aspects of the GDPR compliance. That's the new thing in the GDPR, actually, but they're mostly liable for technicalities, really, like for security, not handling data breaches in an appropriate manner, but not for defining the legal basis, for example.
Yeah. Okay.
This is the responsibility of the controller.
Okay. All right, I think we're going to stop here. We had a couple of more questions, so if you're desperate to have our experts answer them, then please join us on the breakout rooms. But I'll hand the floor now over to John for a summary and closing remarks. And in the meantime, I'll share with you the breakout room link through the chat. Thank you.
Well, thank you to all the experts today for all your input and all your insights in relation to GDPR and the translation and interpreting sector. And also thank you to all the members of the audience who have been with us all during the day and listening and giving us their valuable comments and their questions, which will be taken into account. And as Raisa says, if anyone has any questions that they think that they really need an answer to, please come over to the breakout rooms. So this webinar will end now in a couple of minutes, then we will re-enter a Zoom meeting where we'll create 3 breakout rooms there for specific areas. So if I had to basically summarize today's events, I think it would be that we cannot be passive in relation to GDPR. We need to be proactive. We need to go out and actually learn more about the GDPR and to be more aware and to actually fight for the situation where we know what we're doing and we can identify in relation to the other actors in the translation chain that maybe they're not doing something correct, and then if I can use the phrase, pull them up about it, tell them, that this is the way it should actually be. And that has many, many different aspects. We saw some aspects, for example, that someone is asking you to process data in a way that would contravene the GDPR, or that they don't want to sign a DPA, data protection agreement, where in fact there should be a data protection agreement assigned. So if we're able to, through this entire process of having these working groups and working towards guidelines and producing the report, and then potentially down the line producing the code of conduct, the code of good practice, if we can get the translators all around Europe more aware of what's going on, this will definitely help with the implementation of the GDPR and also safeguard us, because this is, again, as I said right at the very beginning, one of the key aims of this objective is to give you the tools so that you can safeguard yourself, so that you are not exposed to the potential risks of fines or sanctions or any sort of problems, contractual liability, having to pay, and those sort of circumstances. And another thing that I would say is also what Mr. Vivorowski said this morning about the idea of guidelines, that guidelines are essential. It's something that we realized very early on in this process. And it's very heartening for us as the experts on our side to hear that the European Data Protection Board and the European Data Protection Supervisor have recognized, that what we're doing is the right way to go about this. And I think it gives all of us on the expert working group courage to continue our efforts to try and get a set of proper, well thought out, well reasoned guidelines so that all of you can use them. I think that's basically all I would like to say on the topic. I don't know if Raisa wants to add anything else.
No, I just wanted to say that we had over 700 people sign up for this webinar. Some of you have been here with us live, some are watching the recording or selected pieces later, some are watching the live stream over on Facebook. It's clearly a topic that, regardless of how onerous it is to comply, how difficult it is, how many gray areas we still have that we're trying to figure out, it's clearly something that we feel really passionate about and that we feel ownership on, that we want to do the right thing. And that is a fantastic place to be. And we've heard so many times over today as well that our industry is one of the trailblazers in determining how to apply GDPR, how to comply with GDPR on a complex supply chain with very specific challenges. And we want to continue on the work to figure out what are the practical guidelines that will be accepted by local data protection authorities that we've already seen today can have very different interpretations themselves as well. So we want to continue this work and invite you all to be part of that.
And with that, we'll bring this webinar to an end and stop the recording. And hopefully we'll see all of you over in the meeting, and where I will immediately, once we go in, I'll immediately create the breakout room. So we'll have one breakout room for data retention, one for anonymization, and one for risk mitigation. And the various experts will then spread themselves out among those 3 different rooms for people to ask any specific questions that they have. So again, thank you all for your attendance and see you in the breakout rooms.